There we have Ms. Bliss and Ms. Powers who are present. And before we get started, I just want to ask the parties, since they're both here, looks like Judge Basher filed a recusal, and I'm curious what your thoughts are about Judge Hahn hearing this on a family law docket, represented docket.
And Your Honor, it was our hope that we could have been heard on Judge Hahn's docket. Just naturally, when two attorneys are involved, this is the pro se docket. However, Judge Hahn's docket was closed for several weeks. I think it's as of last week, and then I think this week I think we may have just had one more docket closure. So, and given the fact that these parties have gone without any sort of orders for the last month and a half at this point, there are some necessary financial matters that I think we really need to start addressing. So Ms. Powers and I had come to the agreement if the court was so inclined to put it on your docket so that it could be heard sooner rather than later.
Okay, thank you. Ms. Powers?
That's correct. I will note, though, that I was served with the reply declaration and financials last night. I wasn't able to even look at them until this morning. I don't know if the court's had a chance to review them. I don't think it changes anything significantly since we can't respond to a reply declaration.
Let me just
but it did.
Go ahead, Ms. Powers. You're going to say something else.
It did. I just haven't had a time to discuss that with my client.
Okay. And so let me just double check the documents that you received, the reply documents. Let me just pull those up, see if I doubt they're in Odyssey. But I have a large stack. This is the large stack that came my way. Is that what you're both talking about?
I believe so. It was a reply declaration and more sealed financial documents.
Right. Okay. So I received them. I didn't look over them. I'll tell you what my thought process was, and we can kind of talk about that. Is that so? Previously, I reviewed the case when it was last on. I reviewed it. Then I reviewed it again related to the proposed parenting plan. I reviewed some of the financials. There was a lot of documents related to some PayPal information and the like. I reviewed those. I know that Mr. Schuman is a Mason, and that he works in that regard. And then I looked at the issues related to, the cars and the utilities and who stays in home, as far as debts and attorney fees. So I've reviewed it. I haven't reviewed the reply materials, so that's kind of where I'm at. So just so the parties know what I reviewed and what I haven't reviewed.
And Your Honor, I'm fine with proceeding without your review of the reply. It's basically just, again, a re-summarization of my client's position on the various issues, which I think are adequately addressed in her initial declaration. The sealed financials, again, are just more information that has come to light, but most of which have already been addressed in the initial declaration. So I'm fine with, if Your Honor is inclined to proceed today, which is our request, I'm fine.
Ms. Bliss, I apologize. Yeah, I clicked on mute for another person that was speaking or interrupting, and then all of a sudden your picture appeared and then you got muted.
There we go.
Sorry.
No, it's okay. I was wondering what that pop-up on my screen was. I don't know where I got cut off at, but realistically, the financial documents and the reply declaration, I think, are just in furtherance of what's already been provided to the court. I don't think it's anything of real substance that Your Honor would have needed to review prior to today's hearing.
Okay, thank you.
I would agree. We would prefer to go forward today.
Okay, great. As far as the motion, I didn't note who was the initial moving party, so that party can go first.
Thank you, Judge, and that is me on behalf of my client, namely Gloria Schuman. Your Honor's reviewed the file, so I'll keep my arguments brief. What you have before you is a 19-year marriage. With that marriage come two teenage boys, Eric and Alex. It's no dispute, at least from my review of Mr. Schuman's responsive materials, that my client has and should continue to be the primary residential parent for these children. I think the biggest issue before the court, aside from the financial aspect, is what type of contact Mr. Schuman and these children should have. Again, these are teenage boys. Eric, in particular, is in Running Start, taking college classes. Alex is 15, also in high school. These are both very busy and studious boys. The level of exposure that these boys have had to the impending dissolution is concerning, but it has also caused some very big emotions for them. They're angry. My client provides for you that, unfortunately, one of their sons is the one that uncovered the fact that Mr. Schuman was sending money to other women and on the ColumbiaCupid.com dating sites when he attempted to use his dad's computer while he was away. So this has caused some significant frustration for the boys. Obviously, divorce isn't an easy topic for anyone, especially teenage boys. So my client is requesting that the court give them a certain level of discretion, at least at this time. Obviously, as we go through this transition, the boys very much love their dad. My client acknowledges that and wants to furnish that relationship, but she also wants to do so in a way that's productive and healthy for them. She's asking at this time that the court allow them a great level of discretion to see and spend as much or as little time with Mr. Schumann as they desire at this point. I think given, especially Eric is coming close to 18, again, is very busy with college courses and the like. I don't think a standard schedule is conducive to folks who have significant activities and things of that nature. So that's our request today for the parenting plan. As it relates to the finances, Your Honor was provided some substantial financial documentation. My client provides for you that she makes $18.88 an hour, works 40 hours a week, brings home roughly $2,700 a month. The home in which these parties reside does not have a mortgage, but it is severely outdated. My client provides that she believes the utilities are over $1,000 a month. So there's some significant disrepair, which causes some substantial costs. So my client does need assistance. If my client is having the children in her primary care, she shows you her budget. She's in the red, nearly $2,800 a month. So she is asking, especially given the amount of money that Mr. Schumann has been able to send to others. You've been provided PayPal receipts. Some of the documentation I showed yesterday was more receipts that my client was able to find. In 1 year's time of the receipts that she found, he's sent $20,000 to other women. And these are women across the country, across the world. So instead of putting money and food in the mouths of his children and his wife, he's sending money to foreign women in hopes for what we don't know. Obviously, the documentation we were finding suggests that he was seeking sexual encounters with them. He was seeking maybe companionship, whatever it may be. He's spending money that should have been put towards the community on these other women. And so I asked the court to take that into consideration when making your ruling today. Obviously, there's money to go around. Mr. Schumann attempts to have the court believe that he doesn't make a whole lot of money, that he makes the same amount of money as my client, yet he is the breadwinner. He's paid all of was supposed to be paying all of the bills. What you've been provided recently shows that many of those bills remain outstanding. The internet has since been disconnected. My client's getting shut-off notices for the water and electricity because those are several months behind. My client provides to you that instead of spending the party's tax return on these bills, which Mr. Schumann declares in his declaration, he then went to Colombia and spent a lavish vacation with foreign women in Colombia instead of taking care of his needs at home. So there's some significant concerns regarding ultimately the credibility of Mr. Schumann and his statements, but also his waste of the community funds and assets. My client is asking for spousal maintenance in the amount of $1,500 per month. This doesn't cover all of the expenses that she has, but it'll place a good dent in them. For purposes of child support calculations, my client's asking for the court to use her actual income, $18.88 an hour at 40 hours a week. We had to speculate as to what Mr. Schumann's income was. As my client indicates in her declaration, throughout the course of this marriage, Mr. Schumann has essentially kept everything to himself, the financials. She sees the tax returns, but as we all know, as business owners, there's ways to reduce the amount of income you have on paper. My client provides that Mr. is paid in cash payments pretty frequently. We did provide some bank statements that we were able to find in the home. It shows, I believe there's one bank statement that showed $11,000 in deposits in a single month. That's the basis in which we're requesting to impute Mr. Schumann at this time. Obviously, pending further discovery, further documentation, hopefully being provided by Mr. Schumann, we can get a better idea as to what that actual income is. But it sure isn't the $3,000 he's claiming in his declaration, and that's apparent based on all of the factors in this case. The monies that's being sent out, the monies that's coming in, it's not $3,000 a month. So with that, we are asking for our child support worksheets to be adopted, at least at this time, pending further discovery and litigation. We are also asking for a request of contribution to attorney's fees. Again, this is a 19-year marriage. Mr. Schumann has been the breadwinner throughout the entirety of the marriage. Again, my client indicates that she only got a job when Mr. Schumann refused to pay for food and clothes for her and the children. She makes a very modest income. So we are asking for a contribution of attorney's fees and $3,000.
Thank you, Ms. Bliss. Ms. Powers.
Thank you, Your Honor. In regards to the parenting plan, these kids are 17 and 15. My client recognizes that the 17 in particular, that Eric, the 17-year-old in particular, needs a lot more flexibility in his schedule. But my client is asking for a set plan, understanding
Now, I'll catch you later. Bye-bye.
Understanding that he will need to be flexible in terms of the kid's other commitments. But he would still like to have a set plan so that there's something he can depend on and just know and plan ahead for. We're also asking that in terms of the parenting plan that the court not make any limiting factors, 191 findings. Those were listed in the mother's proposed parenting plan. I don't think there's enough information before the court at this time to make 191 factors. So we'd ask that those be reserved or completely kept out at this point. I think bigger than the parenting plan issues in front of the court right now are the financial issues. Primarily, what is dad's income? The father is self-employed. He lets the court know in his declaration that he uses 3 different bank accounts. We have filed all of the bank statements for all 3 accounts for the last 15 months. At the time I was preparing this, it was towards the end of April, so we didn't have April's, but we filed January 2023 through March of 2024. And what those show is an average amount of deposits of $8,412 a month. That gives us a solid gross income number to start with. The father is a brick and tile mason. He explains in his declaration that when he receives income on these jobs and money on these jobs, he gets both the deposit for the materials and also the money for his labor. The actual income part. He explains for you that the average cost of materials is 50% of the cost of the job. As such, we went ahead and deducted 50% from the gross for his normal business expenses. All of this results in the dad having a net income of $3,272. Mr. Schuman does not deny that he has been sending money to other people. We provided all of the PayPal statements for the last year, and they do show an average of $500 per month sent out over the last year. Mr. Schuman understands that his family needs to be the first priority and that going forward, he's going to be paying child support. Based on our proposed worksheets, he'll be paying around $850 a month in child support, which is more than he's been sending out. And that will be a priority over sending money to anybody else. In terms of child support, we agree with the mother's income that she's provided, and we submit that the father's gross is $8,412 a month with a net of $3,272 a month. That all results in a transfer payment of $851.20. We're asking that that begin in June so that there's a little bit of time for Mr. Schuman to prepare for that expense. Ms. Schuman has requested spousal maintenance. By statute, maintenance is based on financial resources, the ability of the paying parent to meet their expenses and also provide for the other household and the standard of living during a marriage. Both parties seem to agree that over the last 10 years, they've lived pretty separately in terms of finances. The father's been responsible for utilities and taxes. Mom has been responsible for food and the kids' expenses. When you look at the net incomes of the parties, they are not far off apart from each other. And it's a situation where the history is not that the father was the main provider of everything. He was providing his portion, she was providing her portion. We don't believe this is a situation where there's enough resources for spousal maintenance to be included. So we ask that the court deny spousal maintenance. The other primary issue before the court is who should be living in the family home. Both parties want to reside there. This family home was built by Mr. Schuman's parents. Mr. Schuman, as a child, teenager, helped his dad build this particular home and has lived there the majority of his life. The downstairs of the home is a 3-car garage, which is full of over 300 tools that Mr. Schuman uses for his trade. At the home is also a landline telephone that Mr. Schuman has used for his business and has your old-fashioned voice recorder machine to take messages. Mr. Schuman hasn't been able to access those messages since he's been out of the house for the last 2 months. We also learned from the declarations of the party that the home is in bad shape and needs a lot of repairs. It's full of the father's work things. It's full of the father's deceased parents' things. And it has a lot of work that needs to be done. We're asking that my client be allowed to move back into the home. Both both parties need some financial support from the father. We agree that he certainly needs to be paying child support. In order for him to be able to provide whatever financial relief the court requires him to, he needs to be able to successfully run his business. Since he's been out of the home, he's been trying to operate with just a limited number of tools, and it has impacted the quality of the work that he can do, and it's impacted his ability to successfully run his business and do the amount of work that he's done historically. With this amount of tools that he has, that he uses on a regular basis, it will be very difficult for my client to find an appropriate and reasonably priced rental where he can reside and set up an appropriate workspace to operate out of for his business. As such, we're asking that my client move back into the home. And if he's in the home, he can take care of the utilities and the property taxes. He does not have enough income to pay for a rental for himself, the utilities for his rental, and then also pay for the utilities and taxes in the home that if the mother is residing in the home. Documentation has been submitted. It looks like utilities for the home are about $1,000 a month. That's pretty significant. The financial relief that the mother is asking for includes child support. That'll be at least $850. She's asking for spousal maintenance of $1,500. She's asking for utilities, which are about $1,000. Plus, my client has agreed to pay Eric's car payment and to pay all of the credit card payments. There is just simply not enough income. Mr. Schumann does not have enough income to pay all of those things. So we're asking that the court allow him to move back into the home. Alternatively, if he can't move back into the home, we're asking that the court give him access to his tools as soon as possible so that he can increase the work that he's doing and be able to do a better job with that. I think that those really are the biggest things in front of the court. We're asking the court to have each party be responsible for their own attorney fees. Again, ultimately, although the father has had access to a little bit more money than the mother, it's still not a situation where there's a ton of money to go around. There's not big savings accounts. We've shown the court what the bank statements are, what is available there, and there isn't enough money to go around the way that would be ideal. Just like in most divorce situations, people are not going to be financially better off in this situation. So it's a matter of trying to make the best of what we have in front of us. So we ask the court to take all of that into account and let the father be back in the home, order child support, deny spousal maintenance, and deny attorney fees. Thank you.
Thank you, Ms. Powers. Okay, so as far as I'll start off with the parenting plan. It sounds like there's no strong disagreement that the mother would be the primary custodial parent, so she'll be the primary custodial parent. And I'll reserve on any 191 factors, so that's reserved. As far as decision making, I'll have that for health and education and non-emergency medical care as limited as to the mother at this point. So as far as visitation, I think it's important that there be some visitation schedule in place, and I also think it's important that when you have a 17-year-old that's doing running start, there's a bit more flexibility that's inherent within that schedule. So as far as Mr. Schumann's visits, I'll set it up on second and fourth weekends from Friday at 5 p.m. to Sunday at 7 p.m. And then as far as Eric, the older son or boy, he'll have the discretion to decline visitations and has a little more flexibility to maybe take a portion of it or not all of it. Whereas the younger son, I think, is 15, doesn't have that same discretion. And then the exchanges will be at each parent's home. And if Eric wants to drive, then he's free to do that. As far as the incomes, that sounds like the greater sticking point. I think there's no question about Ms. Schumann's income, so I'll set her income at $2,794 net per month. Mr. Schumann's income is a little more challenging since he's self-employed as a mason, and there are expenses and there are and taxes are not necessarily a good gauge of what a person's making because there's a significant amount of write-offs, and that's actually promoted, I think, by the tax code itself. Nonetheless, I think there's also concerns that, and there's always concerns with when a person's running their own business, and that there's sometimes there may be cash payments. I don't know if there is or has been, but that's not an uncommon occurrence where people are paid and it's not necessarily registered on the books. So taking all that into consideration, recognizing what the parties have submitted, I'll set his net income at $5,000. So as far as the staying in the home, it sounds like this is the home where the father was raised, and that's where he his parents. This was a home where it's owned by his parents at one time. It sounds like that's free and clear of any debt or mortgage at this point. I think it's important to note that the children have been in that home, it sounds like, for quite some time. And I think that's the key factor, at least in my determination of who stays in the home, is that I'm looking out for the children and not to disrupt them, notwithstanding the difficulties that their parents are having. So because of that, and because the mother is nominated as the primary custodial parent, she'll stay in the home. So Ms. Schumann will stay in the home, and Mr. Schumann is not allowed to reside in the home. He does have his tools and the like, which are important to his trade and his income earning ability. So if the parties can agree on a date in which he could go to the home and retrieve his tools, then that would be authorized by the court. And if the parties need me to choose a date and time, I'll do that. But I assume the parties can choose a date and time. So let me know when I'm done if we need to clarify that a bit more. So then, as far as the debts and liabilities and the like, the indication was from Mr. Schumann that he's agreeable to those things that have been proposed by Ms. Schumann. So we'll abide by that. Next point is the issue of maintenance. Of course, we need to take a look to make sure Mr. Schumann can meet his own needs while paying any potential maintenance to Ms. Schumann. Ms. Schumann's income is relatively modest. She has the cost of it sounds like utilities are a little extra or more than maybe average for that size home. So I'm gonna require $750 per month of maintenance. Both the child support and also the maintenance will start May 1 of 2024. As far as attorney fees, I'll set attorney fees of $2,000 that Mr. Schumann will pay to Ms. Schumann. And as far as the landline phone, I'm not sure what to do with that if there's a specific request, other than I think there's potential that existing phone number can be switched to a different residence. So if that's something the parties could agree upon, that's fine. I don't know what Ms. Schumann's stance on that is. So I'll reserve on actual ruling on that and allow the parties to sort that out. Any questions or clarifications?
I had a couple, Your Honor. One, there's currently a DVPO in place until July 8th, and so I'm not sure if exchanges will work at the mother's residence.
Okay. Do the parties have maybe a more neutral location that wouldn't involve the DVPO?
I'm imagining Ms. Powers and I could probably arrange something so that way we're not having any violations of that order.
I think we can probably work it out.
Okay.
And then my other question is, with the father getting his things, again, we've got the DVPO. So, and there is a substantial amount of things. I don't know if one day will be enough, but hopefully Ms. Bliss and I could work that out. I don't know.
I would say in Your Honor's ruling, we could probably enter a modification to that DVPO to allow for this type of transfer.
Yeah, I think if the parties can agree on the domestic violence protection order that allows for some type of civil standby and to retrieve his tools, the court would certainly be willing to sign off on that.
Okay, and then my last question is that my client agreed to pay the debts. He didn't agree to pay the household expenses. Am I correct to understand that he's paying the maintenance and child support, but you're not going to order that he pay utilities and property taxes on top of that?
Property taxes, I'm going to reserve on property taxes. Utilities, I think Ms. Schumann's in charge of paying the utilities. She's in the best position to control those.
Thank you.
Ms. Bliss, any points of clarification?
And Your Honor, just in that same vein, as my client indicated, there's substantial outdue or overdue payments on those utilities. Is it your ruling that she is to essentially catch those up, or are you ordering that he make them current and then she continue to pay them?
So I'm not sure what the status with, or what this, what the utility provider, if there's back payments owed, if a person continues to make just the incurred payments or incurred charges and still just kind of carries a debt, how does that impact the service continuing?
That's a good question. One of the documents I provided yesterday, for instance, has a disconnect notice on the PUD because there's an $816 outstanding payment. So I don't know if that's sufficient for them, if she just continues paying the new one, or if pursuant to this, she has to pay pursuant to this notice, she has to pay the past due balance of looks like $459.38 by the 23rd to avoid disconnection.
Yeah, my experience has been with the PUD that they generally will work with individuals as long as there's some type of, as long as there's good communication and there's regular payments coming in. So as far as past due amounts, I'm going to reserve on that issue, and then she'll just be current. Just need to keep current on the existing. And if there's any any payments that need to be paid to keep the lights on, she'd be responsible for that. Sounds like it's about $400.
Very good.
Taking a look at presentation, which would be on, we could either do this docket or a Friday morning. Does either party have a preference?
I have no preference.
I have no
Whatever.
preference.
Okay. Today we are the 15th, so we could take a look at the, let's see, the 29th. Let me just double check the 29th of May. Probably need to look at the following week on June 5th. Unless the parties want to turn around by next week. Actually, I won't be here next week. So 22nd, 29th, I'm not here on the docket. So the first opportunity will be on the 5th of June.
That works for me.
That's fine for me.
Okay, so we'll set it for June 5, 9 a.m. for the presentation. Thanks to the parties. Thank you.
Thank you, Judge.
I'll ask if Heidi Ellis, if you're on the line. Right. Mr. Ball, are you on the line? Okay, no response from either. I'll ask if John Ellis is on the line. John Ellis?
I am.
Okay, welcome to you, Mr. Ellis. Just again, let me just call out the name of Heidi Ellis. Heidi Ellis, if you're here, please state your name. And Miss Ellis, if you're on the Zoom call, I'm not hearing you. Just so you're aware of that. We have Miss Turnbull on the line. I recognize that she's present. And then Mr. Ball, it looks like you're on the line. Are you here? Okay.
Good morning, Your Honor.
Good morning. Yep, I can hear you. Great. All right, and just double checking with you, Mr. Ball, is your client going to be joining us today?
Yeah, she's on the line there.
Yep, I'm here.
Okay. All right. Okay, we are here related to Mr. Ellis's motion regarding a change of the parenting plan, and so at this point, I'll hear from him, and then we'll hear from Mr. Ball, and then from Ms. Turnbull.
Your Honor, I have nothing other than what was already in the written declarations, including the follow-up that I filed last Friday in response to Heidi's. So unless the other party has anything new to discuss, hopefully it was all made sense in the written declarations.
Okay, thank you. I did review everything that was filed. All right, Mr. Ball.
Thank you, Your Honor. So the father is asking for what would be a major modification. It currently has some supervised parenting time with some of the children, and limited parenting time. It's kind of a messy plan. It's one weekend he sees some of the children, and the next one weekend he sees the other children. And so my client would like to just change it to all the children go every other weekend. There is a non-professional supervisor who has been working with them, and I think she's agreeing to continue to work with them. But as far as the basis for this kind of modification to going from supervised parenting time and every other weekend to week on, week off, there hasn't been a change in circumstances on my client's part. She's been doing what she's supposed to have been doing and taking good care of the children. And so that's kind of her position. I think, there's still some concerns that she has, and some of the children are still reluctant to participate in the parenting plan. And so we're working on that, but some of that still is resting with the father. So, this is just a temporary plan. We're hoping that we can, at a final resolution, we get a plan that's best suited for the children. So we'd ask that the court adopt her recommendation or her proposed parenting plan, which is every other weekend from Friday to Sunday.
Thank you, Mr. Ball.
Thank you.
All right, Ms. Turnbull, do you have any input?
For me, I do. So one of the concerns with this case is that the children's ages, span from young to to teenagers, and the needs of the children are different. And it's been reported that the father interacts with the older teenagers, the oldest boy, differently than he does with the younger children, and that he does a better job interacting with the younger children. And so that is originally why the visitation was separated, because mom and the younger kids felt more comfortable with dad being unsupervised with the younger kids. And the older two children didn't either want to interact with dad or felt like they needed to have this supervision. One of my concerns all along has been that there hasn't been any feedback from a professional supervisor about those interactions with the younger children. So the supervision has always been from a community supervisor, a lay supervisor. And so we haven't ever had any feedback to give us some direction about what those interactions are looking like. And when either for the younger children or for the older children. And so that is a concern of mine, is that dad has been very compliant in terms of following through with the domestic violence, getting any recommendations, following through with the autism evaluations that his counselor has made, following through with the counseling. He has definitely been making progress and being compliant with all of those recommendations. But in terms of what the interactions with the children are looking like, there hasn't been any feedback about how that progress is going. So that is one of my concerns in terms of making recommendations about moving forward.
And right now with the current parenting plan, the younger children, their visits are unsupervised, correct?
That is correct.
Okay. And then as far as like the feedback that you ideally would have, where would that come from?
Just even a few supervised visits with a professional supervisor, just to give some input.
Okay. All right. Thank you. All right. And then just want to make sure with Mr. Ellis. Mr. Ellis, you represented in your pleadings that you anticipated graduating from the DV program. I think yesterday was the estimated time frame. Did that happen?
That did happen, and the completion letter will be going out today.
Okay. All right. Thanks.
And if I may, can I respond to any of those
You may.
comments? I very much respect the gal's recommendations, both previously and today, and I think that would be an absolute perfect idea to have a few professional paid visits with myself and the children. I do disagree with the other council's assessment that this is a major modification, because we've been operating under temporary plans this entire time, temporary plans that were contingent on the completion of those recommendations. And despite the court, and I already put this in my written declarations, despite the court not adopting any of those recommendations, I completed them all voluntarily. So this isn't a major modification. This is completion of what held me back from having my children in the first place. I know that there's, as Amy specified about Joseph, or the oldest boy, excuse me, but it's been 9 months since I last visited with him. So saying that what happened 9 months ago is still the case and we should hold him to it for eternity is, I don't believe, warranted. And finally, I am looking for this to be a final parenting plan. Heidi wants to move on, and the parenting plan and the division of assets are all that stands in our way. So I would hope that we can come up with something that will not require modification every few weeks. And if we have to postpone it until those professional visits are done, I would certainly welcome that.
Okay, thank you. Just addressing that last piece first, as far as a request for a final parenting plan, unless the parties agree to a final parenting plan, then there would need to be a trial on the matter. So at this point, any order that I make regarding a parenting plan today will be temporary. The one concern that I have is just looking at kind of the history of the case, the life of the case. There was a temporary parenting plan issued on September 28th, and then there's another on December of last year. And now we're here again on a motion to change it. And I think that's where Mr. Ball is indicating that there's not adequate cause. So adequate cause, it's not completely set in stone that there needs to be adequate cause to change a temporary parenting plan. But the concern I have here is that the rapidity or the quickness in which that we've had these evolving parenting plans. And I recognize life is certainly not static, and sometimes there are needs that need to be met through a quick succession of change of parenting plans. But that's the first issue that I raised, and that's the first issue that came to my mind: is there adequate cause, and is it needed? I think given the history of the case, I'm going to be a little more flexible and not require a specific finding of adequate cause to modify. So I'll take the case and look at it at this point. Historically, it sounds like well, what we know with Mr. Ellis is that in the past his thinking has been a bit more black and white, and that tends to be a little bit easier when interacting with younger children. Younger children tend to be more deferring, and when a child gets to be a teenager, they tend to be less deferring, tend to be more nuanced, and kind of stand up and have their own views and thoughts. And so if things are black and white, and when a parent's mind and the child may be individuating or establishing themselves, they may have a difference of opinion there. And there's been some concerning events or unfortunate events that have occurred between dad and the oldest that really make it problematic for that relationship to just hop right back in. So I think as far as the temporary parenting plan, the suggestion from right now, it's the younger kids. There's a split. There's just the younger. I'll call them the younger kids, the younger 3, and then the older 2. That currently the youngers are from Saturday 4 to Sunday at 6, and the older kids is just a Thursday from 4 to 8 supervised. So I think we take into account the fact that Mr. Ellis has completed the domestic violence intervention program. He's continued his counseling. There's a pretty significant analysis and coming to a diagnosis related to the autism spectrum. So I think there's been some progress there, and yet that progress generally is going to be management of his person and his thought processes and the like. So there'll be no change as far as the primary custodial parent. Ms. Ellis will continue to be the primary custodial parent. As far as the younger kids, I'm going to change the visitation to alternating weekends, Friday at 5 p.m. to Sunday at 8 p.m. on the 1st, 3rd, and 5th weekends. I'm just going to note that here. And then as far as the older children, I'm going to set that on alternating Sundays separate. So that would be on the 2nd and the 4th weekends of each month. And that would be from 9 a.m. to 6 p.m. on Sunday. And the oldest boy, he can opt out. And I want the parties to undergo or at least start the process for reunification counseling between dad and the eldest son. And I'm doing that because I think Mr. Ellis has made a showing that he's willing to learn new things and maybe change and develop and improve, and his son may recognize that. And with the assistance of a counselor, that may bear some good positive relationship fruit. So that's the court's ruling related to that. We'll continue with the joint decision making. No change on that. Any questions from the parties?
Yes, Your Honor. I'm sorry, you said Friday 8 p.m. until Sunday?
Friday 5 p.m. until Sunday 8 p.m.
5 p.m. until Sunday 8 p.m. And I know you said 1st, 3rd, 5th, 2nd, and 4th. Being that months have varying numbers of weeks, that could end up meaning that some kids get 2 weekends in a row. I didn't know if that was confusing to the kids or not. We have typically just been operating on odd weeks of the year and even weeks of the year. Is that, what are your thoughts there?
Yep. Mr. Ball, any input on that?
I wasn't aware of that. I mean, I understand what he's saying about sometimes there being consecutive weekends. So I think if my client has been in agreement with that in the past, we can continue to alternate the weekends like that. I don't know. I guess I did defer to her and allow her to make that decision. So maybe it makes it clear. So I'll communicate with them and see if that's what makes the most sense there as far as.
Okay. Yeah, I think Mr. Ellis makes a good point. That could lead to unexpected results. Yeah, the intent of the court is to have the children, the younger children be with father on one weekend, and then the next weekend the older children would be with dad. So the kind of the even on, if the parties want to continue on that process, that's the court's intent. So thanks for that clarification. Any other clarifications?
Yes. Earlier you spoke and said that I only saw the older children on Thursdays, but I do actually see them Thursdays and Sundays today, and you're reducing it to just the same hours that I already get them on Sunday only every other weekend. And I'm worried because you also talked about the frequency of these temporary parenting plans coming. So what happens when we begin reunification counseling and those go well, or quantity, or however that goes? Is this going to be a year before I can come back and get the time back that's being taken away today?
No, I think the reunification counseling is that if a counselor makes a recommendation, the court is generally positively responsive to that if that's it going in a good direction.
Okay, and then the other one is my black and white thinking at the beginning of this process a year and a half ago, or whenever the actual first court orders were entered, even caused problems with the children's visitation, and that is, do we force the children to go? And I have learned since that does not benefit them at all. And so, as you have seen in the declaration, I haven't forced the older ones to go. And I would like clarification. You said only the oldest can opt out. What does that mean for my teenage girl who's going through a change in her life, and she loves to visit one day and doesn't want anything to do with me the next day, and then 2 weeks later it'll repeat? Is it being forced upon all but the oldest?
That's the court order. Okay, so we'll take a look at a date for presentation. The parties want to take a look at your calendars. They would be on June 5th at 9 a.m. How does that look, Mr. Ball? Looks like you're muted, Mr. Ball.
I can do June 5th. I'll prepare the order as well.
Great, thank you. Mr. Ellis, June 5?
I can do that, and I would just ask Mr. Ball, please keep with the current wording of even and odds, because I already have plans for the kids that I have on the odd weekend, young kids and old kids. They're booked out already.
All right.
Okay, I'll send that over to you, and you can get back to me about if there's necessary changes.
Thank you.
Okay, thanks to the parties. We'll see everybody on June 5th, unless that's submitted and agreed, and I'll sign off on it prior to that.
Thank you.
And does it begin now or not until June 5th?
The intent of the court is that starts now, and then the parties will reduce it to writing, and it'll be signed on June 5.
Received. Thanks, sir.
Okay.
Hi, I'm
next
here.
Is, okay, Ms. McKinney is present.
Yes.
Then we have Ms. Jensen. Ms. Jensen's present. She's representing Heather Fontes.
Yes, Your Honor.
Great. How do you pronounce your client's last name?
Fontes.
Fontes, thank you. And then I'll ask if Mitchell Stemmerman is on the line. Okay, there's not getting a response from Mr. Stemmerman. So we have Ms. McKinney here and Ms. Jensen on behalf of Ms. Fontes. And is Ms. Fontes on the line?
I am.
Okay, all right, welcome to you. All right,
Thank
so this is Ms. McKinney's motion, who is the mother of Ms. Fontes and also grandmother to the young child. And I guess my first question to you, Ms. McKinney, is that you filed this under kind of a parenting plan action, cause of action. And can you tell me why? Because my thought is your motion is more appropriately a minor guardianship type of case. So I'm inclined to dismiss this case because I think it's not the right type of case, and that may seem overly formalistic or strict or what have you, but I think that the rules require that. So I'll just hear from you on that issue, if you could, please.
Well, it's because I'm representing myself. I wasn't sure which to do that under. I was actually going to come to court to ask if Your Honor would consider engaging Heather, Hadley's mom, and myself engaging in a mediation process proposed to facilitate a mutual resolution. And under guidance of a trained mediator, I firmly believe that this collaborative approach does hold the potential for positive outcomes, provided both parties are willing. But I also had some other information that recently came up. I recently was told by my partner and Hadley's papa that he'd provide representation, legal representation on my behalf. However, before proceeding, I was hoping we could go to mediation. That is, unless it's thrown out right now. So I'm just kind of waiting to see what happens, I suppose. I'll
Okay.
just use your honor's, discretion regarding, this consideration.
Okay, thank you, Ms. McKinney. Ms. Jensen?
Your Honor, it would be our position that this case should be dismissed. I agree with the court's analysis that it's not properly brought before the court. It would be more of a minor guardianship, and I would also submit to the court that it's not even appropriate there. As the court may recall, Ms. Fontes and Mr. Stemmerman are actually engaged in a custody parenting time case. We have a GAL on that case. Both parties are engaged in parenting time on that case. So I don't even think it appropriately fits under a minor guardianship when we have two ready, willing, and able parents that are available and engaged in litigation regarding this minor child. So I would just ask that this case be dismissed.
Okay, thank you. All right, Ms. McKinney, you raised the issue of mediation. Potentially if the parties, any party, two parties can agree to mediate, and if that's your intent and there's agreement, then certainly I'd encourage the parties to do that. Sometimes a third party helps to bring people together. As far as this case, where there's a request by Ms. McKinney as a grandparent to have visitation with the minor child, her granddaughter, court's gonna deny that. It sounds like the parties are in the parties, meaning Mr. Stemmerman, Ms. Fontes, are in litigation over the same issue. And there's some pretty strict guidelines in the Supreme Court spoken about grandparent visitation rights. It's not necessarily a right when you have two parents that are active and able to care for the child. So I'm going to deny the motion, and I'll take a step further and dismiss the case. Ms. Jensen, would you be in a position to prepare those orders and submit for signature?
Yes, Your Honor, I can do that.
Okay, great. And if you could just send just a CC copy to Ms. McKinney so she sees what's coming.
Of course.
Appreciated.
Yes.
All right. With that, does any party have any question?
No, thank you, Your Honor.
No, Your Honor.
As far as parties, I see
All
that
right, very
Mr.
good.
Lawrence, that already on the item, is present. He's online.
you.
I'll ask if Stephen Utter is on the line.
I'm here, Your Honor.
Okay, welcome to you, Mr. Utter. And I'll
you.
ask if Kirby Young is on the line. All right, Kirby Young, if you're on the line, please unmute and state your name, Kirby Young. All right, not hearing a response from Ms. Young.
Your Honor, I see her on the board, but we can't hear her though.
Oh, okay. Thanks, Mr. Lawrence. I appreciate that. Let's double check. All right, Ms. Young, it looks like you're unmuted as far as Zoom's concerned, and your camera's off. So if you're here, please state your name. Okay. Well, I'm not sure what to do, Ms. Young. If you can hear me, and we're unable to hear you, so there's no audio coming from you to us. Sometimes that's best rectified and solutioned by logging out and logging right back in. So if you want to do that and you log off, that would be a clear indication that you're able to hear us. And then we would just wait just for a bit for you to come back on. Looks like she just dropped off. Maybe what we could do, if it's okay with you all that are on the line, Mr. Utter and Mr. Lawrence, I have one matter which I think is going to be short. I can call that, and then I'll come back to the Utter and Young matter if that's okay. Fike is on the line.
Yes, I'm here.
Okay, welcome to you, Ms. Fike. And Joseph Sorensen, are you on the line?
Yes, I'm here, Your Honor.
Okay, welcome to you, Mr. Sorensen. We're here on a motion brought by Ms. Fike regarding the lifting of a restriction as it pertains to her mother, Jill Hall, who's the grandmother to the children, her child. This stems from a November 17th, 2020 order issued by Judge Basher, which indicates that Ms. Hall was prohibited from having contact with the child, and that she could have contact with the child if several things happened. One was that she involved herself and completed a state-certified SUD, substance use disorder treatment program, and that she provided clean hair follicle tests. And it is a plural word, test, so it's tests. So I reviewed the clean hair follicle test that was showing no substances from June of 2023 from Ms. Hall. So I'll hear from Ms. Fike and then Mr. Sorensen. Ms. Fike?
Yes, as you were stating, Judge Basher ordered a no in-person contact between my son and my mother due to hearsay from others accusing my mother of drug use drug use 3.5 years ago during my custody case. The respondent has said that I was one of those accusers when in fact I was not. I have never said that. I apologize. I've written declarations against Rhonda Larson's report stating different things that I have never said that were in her report, including her saying that I didn't want my son to have contact with my mother. There's no reason for me to bring my mother into my custody case. If I suspected anything, then I would have stopped their contact on my own. I wouldn't have needed the courts to do that. The respondent states that Jill Hall has been absent from our son's life since 2020, but that's not the case either. When Christopher is home, he talks to his grandma often through text, phone calls, and even FaceTime, because the restriction was only for in-person contact. The only contact they haven't had is in person. To say our son doesn't want to see his grandma is 100% false. Christopher asks me regularly, when does he get to see his grandma, that he misses her so much. And Christopher told me the other day that he talked to his dad about it. Then all his dad said was, that's up to your grandma. For the respondent to say that he believes I filed the motion to create a continued court conflict is appalling. I filed this motion so my son can be reunited in person with his grandmother. I filed her hair follicle results last year. I was told by the clerks that all I need to do was file the results and to bring it up in my next court date, which I have more than once, and it was ignored. The text messages between my mother and my son were already brought up and dealt with, and those are over a year old. She has not talked to my son about anything in over a year. My mother's influence in our son's life has only harmed the respondent's relationship because he has never liked my mother. My mother's test results would have been current if it was paid attention to when I filed it the first time. Her license and her car insurance were already provided to the
Can I
court.
ask you a question, Ms. Fike?
Yes.
You said that the test results from June of 2023 were previously filed. Is that correct?
Yes.
Okay. Was it filed?
Maybe in September, maybe a few months after she gave it to me, because I wasn't sure how to file. And then I went to the clerk's office and tried to file this same motion, and they said, this is how you do it. We'll just submit the results and you just bring it up in your next court case. So that's what I've been doing, and it's obviously been wrong. So now I filed this motion again.
You're saying you filed this a second time?
This is the second time I filed my mother's test results, yes, under seal.
As far as a motion, though, was there any prior motion related to?
No, because I went to do the motion and the clerks told me that it wasn't the right way, and to just submit, since I already had a court case going, to just submit those results into court and then bring it up in my next court case.
Okay. All right. Thank you.
And I explained to them I needed a motion, and they said, no, just do the test results. So that's what I did. Okay. They haven't seen each other in 3.5 years, but they've FaceTime, they've talked, they've had communication. It's not like they have not seen each other in almost 4 years, but he's devastated and would really like to see his grandmother.
Okay. Thank you, Ms. Lake. Mr. Sorensen.
Since she declined a drug test, Jill has been away from our son's life for over 4 years by choice. Our previous GAL and Judge Gary Batcher found that her likely drug usage and parent alienation of Tiffany and myself were both issues, so they ordered no contact and requested drug testing. Mine and Tiffany's comments to the courts and GAL that her mother's involvement into our son's upbringing by both of us are documented. The text between our son and Jill Hall that I have filed show she includes him in adult and court affairs, lies to our son, name calls his stepmom, blames my wife for her drug test, terrifies, guilts him, interrogates him, and talks negatively to him a lot of the schedule with myself. My goal is to provide our son with healthy influences, especially from family. Since the January custody transfer to myself, our son is healthier than ever, and I ask the courts to safeguard that. Reuniting our son with Jill should be a process. Our son is now 15 and a half and was a child when last saw Jill. I support whatever healthy efforts Jill takes to be a positive influence in our son's life. I love our son more than any dislike I have for Tiffany or her mother, Jill. Tiffany submits a drug test allegedly taken by Jill nearly 10 months ago, not a current one. Tiffany has been petitioning for her mother in court to see our son, not Jill herself. I'm asking the courts to see that. Jill Hall's drug screen to be current and taken on site, that the courts verify results and institution. If granted, or visitation should come with restrictions to avoid further alienation and disparagement of any kind. Our son is doing well in school and mentally. I'm nervous about any disruptions that can throw his success off. Introducing Jill back into his life abruptly with no restrictions or proof of a current class test is risky.
All right. Thank you, Mr. Sorensen. All right. So I think the key is to look at the November 17, 2020 order, which says that there's to be no in-person contact with Jill Hall and the child. And then the judge indicated that there can be contact if there's completion of a state certified SUD treatment program, and that Ms. Hall provide clean hair follicle tests. So number one, there's some, at least kind of in the back of my mind, there's some concern that it's been 3.5 years and there was a hair follicle test that was given in 2023. I don't have any proof of any SUD treatment completion. So one of the preconditions or conditions for any type of visitation indicates that there's not been an SUD treatment program that's been completed. So by that term and that term alone, then there would be a denial of the lifting of the restriction for the visitation for grandma. Secondly, that the court order from November 2020 indicated that there needs to be provide clean hair follicle tests, and it's using the plural tests, it's not singular. So therefore, we have one clean hair follicle test from June of 2023. If there were to be a second one, a more current one, then that could be addressed in conjunction with proof of completion of the SUD treatment. So those are the preconditions that are antecedent conditions that need to be fulfilled before a motion would be properly entertained. So at this point, I'm going to deny the motion to lift any restrictions.
Can I ask a question?
So the November 2020 order still remains. You may.
Okay. I haven't talked to her about the state certified treatment in a couple years, but she told me back then that there's no reason to go to, the treatment if she's not on drugs. So she has that clean hair follicle test. So what if she goes to go into treatment, but she's clean? Do they still do a treatment? Or will they just sign off right then saying that she's clean and she doesn't need treatment? So how does that work since she's already taken a clean hair follicle test? I'm just confused on that.
So the court's decision, let me just pull it up here again. It says any in-person contact between the child and the grandmother needs to stop until such time as the grandmother can provide proof of completion of a state certified SUD treatment program and provide clean hair follicle tests. Upon completion of those requirements, the court would entertain a motion to lift that restriction. So generally, before any type of treatment occurs for SUD, there needs to be an evaluation. If the evaluation recommends treatment, then that treatment program would need to be completed. If there's an evaluation and it recommends that there be no treatment, then that ends the inquiry at that point, that there's no further requirement. And so there we go.
Okay, so, thank you.
So I will prepare a short order that's denying the motion. I'll have that filed. And any questions from you, Mr. Sorensen?
No, Your Honor.
All right, that'll conclude today's hearing. Thank you. Kirby Young, are you on the line?
Yes, I am.
Okay, great. Thanks for your help in getting so we can hear you.
Yep.
So Mr. Lawrence, you're still on the line with us?
Yes, I am.
Great. Mr. Utter, are you here too?
Yes, sir. Okay.
Perfect. All right. So it looks like back at the last hearing, which was in March, middle of March, the indication that the child was not interested in participating or was highly reluctant to participate in a reunification. There's an indication we'd give it 60 days, see if there's any improvement. So I'll hear from Mr. Lawrence.
I have reached out to both the parties and they have not responded to me. So I don't know if there's been any progress at this point, Your Honor.
Okay. Thank you, Mr. Lawrence. Mr. Utter?
Yeah, since then we've had a couple reunification counseling appointments, and unforeseen circumstances, whether it's between myself one time wasn't able to make one, with Kirby wasn't able to make one, and then with Patricia has broken her arm and has had to reschedule the last couple visits, so we haven't had those. But we were pretty much at the same place with Parker, not getting much out of him. Little bits of progress here and there.
Okay, and when you said Patricia, that's in reference to the counselor?
Yes, Your Honor.
Okay, thank you. Ms. Young, any input you'd want to share?
Yeah, so we've done, I believe, one since our last court hearing, and Parker still doesn't want to do it. I've told him he's got to do, a few more to see how it goes. And again, yes, the counselor has canceled the last couple, and I don't know if we've been doing them once every 2 weeks.
Okay. Is there an appointment currently scheduled?
So it isn't for that fine.
Yeah, that's fine.
Okay, but we can do. Oh my God, is that?
I don't believe so, Your Honor. I don't have any
She was supposed to reach out. Because she's doing
Surgery.
a surgery. So she was supposed to reach out to us when she could continue the Tuesdays at 9 a.m.
You're muted, Your Honor.
I can't hear anything.
I'm not muted. I didn't touch anything.
There you are.
Can you all hear me?
Yep.
Okay. So just any additional feedback from either of you? That
I think we're just kind of waiting on the counselor to tell us when our next appointment would be.
Sure. Mr. Utter, anything final?
No, nothing final. Absolutely not final. But yeah, I agree with Kirby. Just kind of waiting for her to proceed. And like I said, there's flashes of something with Parker. But at the same time, he's very reluctant. So I wish to just continue the way we are, and hopefully we can break through here.
Okay. All right. Thanks. All right. So I think what I'd like to do is continue the matter to July 24th. That's a Wednesday, July 24th at 9 a.m. Hopefully that'll give additional time. There's been some intervening forces, a broken arm and some difficulty with scheduling that really have prevented any meaningful opportunity for any potential progress. So I'd like to give those reunification counseling appointments an opportunity to take root. And if they do, we can come back and we can discuss it. If they don't, we can come back and discuss it. So that's what the court's looking forward. And I'm not sure if the parties have signed releases of information so that Mr. Lawrence can get that information. If you haven't, then they have.
Your Honor, I've spoken to Patricia in the past.
Okay, perfect. Great. That'll allow hopefully an update for July 24th. And just confirming that date works for everybody, Mr. Lawrence?
Yes.
Okay, Ms. Utter, or pardon me, Mr. Utter?
No worries. Yeah, July 24th is fine.
Perfect. Ms. Young?
Yep.
Great. We'll see everybody then. Thanks for your attendance today and input.
Thank you.
Welcome to you. And Ms. Brianna Nyberg, are you on the line today? All right, Brianna Nyberg, if you're on the line, please unmute and state your name. Okay, I'm not seeing her on the Zoom call. I don't see her in the courtroom. If she is in the courtroom, come to the council table if you would, please. All right, there's no movement. And again, I'm looking at the participant list on Zoom. I'm not seeing a Brianna Nyberg I'm looking under B's, and then I'm going to look under N's for Nyberg. Not seeing any response there or persons with that. So this is the state's motion for child support. It looks like service was properly effectuated by mailing. So we have Ms. Looney here. I'll hear from her, and then we'll hear from Mr. Rovario.
Thank you, Your Honor. The state's motion is for temporary child support. We have calculated that based on Mr. Rovario's history of working at minimum wage. We have calculated him at an imputed wage of minimum wage 35 hours a week, which would give him a net income of $22.10. Ms. Nyberg is currently receiving TANF, so we have imputed her at TANF wages, which is minimum wage of 32 hours a week, giving her a net income of $20.35. The resulting support payment that we are requesting is $452 a month from Mr. Rovario to Ms. Nyberg, and we're requesting that begin April 2024, which is the month that the child began receiving TANF after the father was no longer in the household.
Okay, thank you. All right, Mr. Rovario, do you have any input related to that request?
So I've been unemployed since January of this year, and from my knowledge, Brianna was receiving TANF about half a month to a month before I had left the household, February 24th.
Okay. All right. And are you currently employed or still looking?
I'm still looking.
Okay. All right. All right. Very good. So it looks like the state relied upon what's called the employment security data. It gives quarterly earnings that are reported from employers to the state, and they gather that information. And so it shows historical earnings by quarter. And I recognize, Mr. Rovario, that it sounds like you haven't been working since January. Prior to that, there was indication that you were working, and it looks like it was generally an average of about $2,200 a month. So notwithstanding the fact that you're not working currently, children's needs continue whether a father or mother is working or not working. So I'm going to set that child support level for the father at a net of $2,210. For the mother, she's imputed to a higher level than what she's actually earned in the past. because there's no indication that she's unable to work, and so she's imputed full-time minimum wage. So that's $2,035 net. I'll set the incomes at that, and with those incomes being set at those levels, that results in a transfer payment or a child support payment of $452 a month. And I will have that start on April 5, and it'll be due on the 5th of each month thereafter. So that's the court's order. And so Ms. Looney, I think you have prepared those orders and submitted those documents to the court, so I have those here. So I will just put a note to go off and sign off on those. And then just want to mention, Mr. Rivara, you mentioned in your pleadings that you're not able to really see the child and the like. And so if there's concerns that you have related to that, which it sounds like you do, you'd need to file a motion and note that up for a docket and have the court make a ruling on that request. So I just wanted to give you a heads up on that.
I did put in a motion of default and order of default, I think 2 or 3 days ago.
Okay. All right. So as a general rule, those will be processed through. Once the court gets to look at them, then there's a 2 or 3 day lag time for them to be processed and uploaded into the system. So if that doesn't come to fruition as you'd hoped for, then you could certainly file note it up for a motion. But if we'll have to kind of wait and see what the process is and see if it's been uploaded.
Okay.
All right. Very good. That'll conclude today's hearing. Thank you.
Thank you, Your Honor.
All right. And then Ms. Looney, as far as additional cases, I think are you going to be signing off and not coming back? Is that accurate?
That's correct, Your Honor. I have to go to the state's initiated dockets. We do have a couple of other matters, but I don't anticipate child support being addressed on either of them today.
I'll ask if Mr. Lyon is on the phone. Thank you.
Thank you.
Yes, I am.
Okay. Welcome to both parties. All right. So we have a little more updated information as it relates to CPS and law enforcement. Have confirmation that the Thurston County, they are not pursuing any charge or filing of any charges at this point. Washington DSHS, as of May 10th, they indicated that the allegations of abuse were unfounded. Oregon, as of April 10th this year, made an opposite finding of founded with a reasonable cause to believe that abuse did occur. And Umatilla Police Department apparently is still investigating, and the parties can correct me if that's incorrect, and that there's no decision at this point. So that's what I know from reading of the pleading. So I'll hear from you, Ms. Jablonski, and then hear from Mr. Lyon.
Okay, so I spoke with Detective Morris. I provided one of his emails in the attachments, actually.
And where's Morris from?
He's from Umatilla.
Okay, Morris is, okay.
Yes, so it's in one of the documents, and he handed over jurisdiction to Washington and said he had no criminal proceedings.
That vaguely sounds familiar. Do you know what document that was included in?
Ooh, well, I've submitted so many documents.
And it was you said it was like a screenshot of something that he had sent?
It was an email between me and Mr. Morris. It was on March 12th of 24.
Okay. So your indication from, at least from Mr. Morris, Officer Morris, is that they kind of washed their hands of it and said Washington State authorities,
Correct.
you take care of it. Okay. Okay, that's helpful. Thanks. Mr. Lyon, does that sound familiar to you or no?
Yeah, basically what I know is that he pretty much sent it over to Washington saying like this is a case that occurred in Washington, so Washington should be the one in charge of handling that.
Okay.
And that's about as far as I know.
Okay. All right, thank you. So Mr. Blonsky, with so no criminal charges, it sounds like, either in Washington or Oregon are being pursued at this point. And then we have dueling CPS letters. Can you help me understand what your position is related to that?
Okay, so I've had 2 social workers come to my home. The first one was Scott Dueñez. I had him, but then we went over our extension. CPS is only given like 30 days to find a finding in the case, and if that doesn't happen, then it goes to Regions. So I had Regions then come into my home, do the observation again, the full investigation. So, and then when she came into my home, I want to say it was just a few weeks ago, she came into my home, did her inspection and everything, and said she had found it unfounded as well, which I provided that letter.
So that's the Washington.
Correct, Rosie.
Right, and that was the April 10th letter or May 10th letter.
Yes.
Okay. So that's all those efforts were related to Washington social workers.
And we have my son's therapist down in Pendleton as well, saying that he did not disclose anything in regards to that matter, which I provided.
I would like to
Right. Hold on,
But-
Mr. Lynn. And Ms. Jablonski, that letter that you mentioned from the therapist, how long has your son been visiting with that particular therapist?
I don't have a timeline for that. Dad would know better on how long he's been seeing the therapist. She's limited to what she can and can't share with me.
Thanks. Mr. Lyon, do you have an idea of how long?
Yeah, he's been seeing the therapist for maybe a little over a month. And to the therapist, I've spoken with the therapist, and she said that apparently that Miss Nancy misquoted her. She just simply meant that Carl had disclosed nothing new, but he has made disclosures.
And is that in any of the documentation that's been presented to the court?
No, not this time.
So how does she know that there's been past disclosures? Has that therapist received those disclosures?
So she was the referral from the trauma center, the place that did Carl's forensic interview. So she was already on the know with his with this case.
And that was so she received the case as a result of the forensic interview. And at the forensic interview, that's where you're saying disclosures were made?
Yes, that is where my son had said specifically that let's see here, that he said that he was not keeping a secret because he told his grandma stuff he wasn't supposed to. He disclosed that his mom's boyfriend Chris is his quote unquote enemy. Carl said that Chris is inappropriate with him. He said that Chris is being a mother effer. Chris touches my privates and draws on my pajamas. Chris came into my room, pulled down my pants, and touched my ass with his hands, and while I was sleeping. And Chris apparently ran away laughing afterwards. That was the disclosure that he made in the forensic interview.
So what's interesting about that, those are pretty graphic descriptions, and yet we have one agency, CPS in Washington, says that's unfounded, and we have another police agency that says they're not pursuing any criminal charges. Help me understand your position related to that information.
Related to like Miss Santi, you want my personal opinion or?
Yeah.
Okay, yeah. So Nasanti had called off the whole interview based off of an interview that his mom had done with Carl one-on-one during one of our visits. And I believe that Carl was heavily coerced into making an admission saying that he was lying about all these allegations.
Okay. All right, thank you. All right, Mr. Blonsky, at this point, you indicated that there was some concern regarding the phone call interruptions. I think I'm just going to be very clear on that. I think that the prior order is that the paternal grandmother is not to have any involvement in those phone calls. And I recognize children walk around while they're talking on a phone. And so it's going to be incumbent upon her to exit any particular room in which the child's in, even if the child's wandering. I just want there to be just as clean of an environment, if you will, as far as untainted by any past relationship issues between the adults. So hope that clarifies that. There's not to be any phone call interruptions. It's just supposed to be the child and the monitoring by father. Do you have any questions about that, Mr. Lyon?
No, I don't.
Okay. All right. So at this point, I'll hear from Ms. Jablonski. If you have any proposals, then I'll hear from Mr. Lyon.
Yeah, actually I do. So in some of the statements, they watched the video of Carl's forensic interview. It states that Carl was extremely difficult to interview and easily distracted. He was playing with Play-Doh during the interview and continuously had to be redirected with questions. And then, they've spoke to the therapist. We've spoke to 2 CPS people, 2 detectives, and we've got 5 people on the Oregon and Washington side, all saying unfounded. Amanda Hall and then Casey Talbot. I've sent an email to Amanda Hall. I want to say it was April 26th, which I got documents of that. No response. This Kathy Talbot has been out on emergency leave of absence for over a month now.
These are Oregon people?
Yes. And they should have given another caseworker to work with me. I should have gotten some kind of answers from them, some kind of, somebody should have reached out to me. Oregon has been very difficult to work with.
What's the status of the appeal?
The status of the appeal is they've got 31 days to respond to the letter. So that appeal was sent out on May 1st.
Okay, so by June 1st, we'll have some type of at least acknowledgement.
Hopefully.
Okay. All right, go ahead. Because I was asking about if you had any requests.
Do I have any requests?
Mm-hmm.
If we're going to continue on with visitation until we get that letter appealed, I would like for it to be in Washington. It has been super challenging and hard. I'm getting up at like 5 a.m. and driving to Pendleton, which is 5 hours away for me, all the way from Olympia. I'm not getting home until 11 p.m. You know, it's a struggle. Or I'm having to stay in Pendleton Friday nights just to make the time. You know, and when I do stay in Pendleton Friday nights, I'm setting a time with dad. Dad's not making those times, so that extends my visitation longer.
When you say he's not making the times, what does that mean?
So we had agreed to so if I stay in Pendleton Friday night, right, because the drive's so long, I try and do my visitation as early as I can, so that way, you know, I'm not on the road super late at night. If that makes sense.
So meaning that there's an agreed upon time, that agreed time is not fulfilled.
I would like to
So
step
hold
in
on,
real
I
quick
have a
and say
question.
that
I'm asking Ms. Jablonski a question. Hold on. So are you indicating, Ms. Jablonski, that there's a set time and then that set time is not honored?
That is correct.
Like, for example?
For example, I have some text message where we were supposed to meet. I want to say it was like 9:30, 10 in the morning. And Mr. Lyon's like, sorry, you know, the children had just woken up. Then the kids tell me that they had been up, and I get stuck waiting a half hour at the location.
Okay. So a half-hour delay is what you're talking about?
Yeah.
Okay. Okay, so you've indicated that it's a very long day, and then I'm not quite sure if you'd made a request or not of the court.
What was that? Sorry.
You described that it's a very long day for those visits, and I'm not sure if you had made a specific request.
So I guess my request would just be that, you know, he be on time. If I'm gonna drive down to Pendleton and make that effort, then the times need to be at a set time, so I'm not having to extend it over.
Okay, all right. Okay, so at this point, do you have any concerns, Mr. Lyon, about just encouraging all parties to be timely and related to the visits?
what was that? Sorry again?
Any concerns if all parties are just on a heightened alert, just to be extra cautious and conscious?
Hush. As far as, I just want to address some of these concerns. I would also
Hold on.
say that-
We don't need to get into those concerns at this point. I just specifically, do you have any concerns that just all parties are encouraged to be timely in the execution of the visits?
Yeah, sure. Yeah.
Okay. All right. So I think at this point so what we have now is that there's a founded finding by Oregon, unfounded by Washington, and not filing any criminal charges, either Washington nor Oregon. There's an appeal process which is being undertaken with potential more information as of June 1st. I believe that was the time frame, June 1st. So my intention today is to keep the March 25 order in place in the time being. Recognize that it puts a lot of extra strain on the parties related to that, in particular Ms. Jablonski, and continue the matter for review post June 1. And I'm not quite sure, because June 1, we may not have a decision on the appeal. We may not. So I'm proposing that we come back 2 weeks after that first part of June on June 19th for a continued review to see if there's any updates on the appeal, if there's any change on their finding of founded. Any concerns if we did set it over to June 19th?
No.
Okay, Mr. Lyon?
No, I was going to request that we hold it over till at least June 8th anyways, because the kids have school till, you know, early June, so.
Okay. I'm going to double check. I've got a notation here. June 19th, is that a court holiday? Because that's like a new holiday, isn't it?
I have no idea.
Okay, so I guess that's a new holiday, June 19th. So we need to look at a different date. Thanks for confirming that, Madam Clerk. June 26th. Let's come back on June 26th and to review if there's any updates related to the appeal of the Oregon founded letter.
Okay.
Does that work okay?
Yeah. So I just
Yeah.
want to
Okay, thank you.
clarify a couple things too
Go ahead.
in regards to the extension. So grandmother is not to interfere. I did have a couple phone calls where dad had, I submitted text messages. I attached them to some of the documents that you have. But I'll be on the phone with my daughter, for instance, and he will start yelling, raising his voice, cussing at me. And I told him that he was being inappropriate. And
That would be a phone interruption, and that's not
yeah.
that's
Okay.
not allowed.
So I just want to know.
Yeah, that's not allowed. That's not allowed. Yeah, the monitoring is to occur. Yeah, and if there's any issues related to that, I think that's, you know, it's those are difficult situations, and I think I was clear as far as the grandmother's involvement. She's not to be involved in any way, shape, or form, and that the monitoring means that there's monitoring and that there's not interruptions.
Okay. And there is a time frame where dad is away at work and grandma is with the children. Now, I know that that can't be controlled on what's said, but I do ask that there be some kind of brown lines to where grandma cannot bash me in front of my children. There has been reports from my children that grandma's training them not to talk to me, and my son provided exactly like step one. Grandma said, don't talk to you when we arrive at visitation. That is parental alienation, and I'm not for it.
All right, so this is a separate matter than what it was docketed for. So if there's concerns related to that, that certainly can be raised when we come back on June 26th. Certainly, if there's any efforts, disparagement of another party by any other party is it's not right. It harms children when parents are disparaged, no matter the source. So just encourage all the parties to be very careful and conscious and scrupulous in how they address the other party, and including family members to control them. And if you can't control them, then you remove the children from that situation so they don't hear that. We'll be back on June 26th.
Yeah.
Thanks. Great. Welcome to you, Ms. Marquez. Could you please turn on your camera? Okay, thank you, Ms. Marquez. And we have Mr. Is it Sekni? Please take a seat. Mr. Sekni's in the courtroom today. All right, we're here on a couple of different matters. So let me just tell you why I think we're here, and then you can correct me if I'm in error. So what I have here is that one is a motion for contempt that Mr. Sekni has brought, and I show that the service of that was effectuated on May 2nd upon Ms. Marquez. Ms. Marquez, did you receive the paperwork related to the contempt?
No.
Okay.
It was the other way around, sir.
Oh, it was the other way around. Okay, thanks. Ms. Marquez was filing, here, I had it right, I just read it wrong. So this is Ms. Marquez's motion for the contempt, and then Mr. Sekni received the paperwork. I'll ask you if you received the paperwork on the contempt.
Yes, I did.
Great, thanks for the clarification.
What's that?
No, I was just curious about the individual in the back that was talking. And then there was a motion for adequate cause that Mr. Sekni brought, right?
First, I filed a motion to change the parenting plan. That was,
Yeah,
and then I received this in response.
Right. Yeah. Right. So there's a motion for adequate cause, which would allow for a modification of a parenting plan. So I'll double check with Ms. Sekni if you received those documents related to his motion for adequate cause and a motion to modify.
Yes.
Okay. One thing, so let's talk about that one first, because that was the one that was filed first. So we're talking about Mr. Sekni's motion for adequate cause and the motion to modify the parenting plan. So service is a big deal in court proceedings. It's kind of based on the whole idea of notice and opportunity to be heard. So everybody knows what the other party is saying. And those rules are generally interpreted fairly strictly in that there needs to be either personal service. Here with a motion to modify, there needs to be a summons served, and also the petition, and also the motion. So what I saw was that there was an affidavit or declaration of service that was filed, and it states that a fellow named Jared Jason, served court documents, and he wrote on Spencer Sekni, not on mom. So I'm assuming that was a mistake. I'm assuming it was a mistake. And he indicated that he served several documents, but there was not an indication that he served the actual summons on Ms. Marquez. So there's a couple of problems there that need to be rectified.
He said that, or the other party said that?
Yeah, let me just let me pull it up, and then I can explain it a little more clearly. So as far as that motion, the service of the documents related to the adequate cause motion to modify, this is what I have. So this is filed on April 29th of this year. Oh, Ms. Marquez, just so you know, just the paper shuffling comes across really loud in the courtroom. No, it's okay. So the proof of personal service says, my name is Jared Jason. I'm not a party to the case. I served court documents for this case to Spencer Sekni, giving the documents directly to him, and it happened on April 27th. And then he says he gave a petition for a change of parenting plan, the proposed parenting plan, and then the declaration of Spencer Sekni, and a motion for adequate cause decision and notice of hearing. there was a summons that was filed in relationship to that motion for modification of the parenting plan, and that was left off. That box was not marked. So there's two issues I have with the proof of service. One, Mr. Jason said that he served you, which he should have served her, which I assume he did. And then the other issue is that he didn't give her a copy of the summons. So what I'm saying is that I don't think we can move forward until those two things have been fixed.
Okay, so my question is, how do I get those two things fixed? Because she was served with all the paperwork.
Yeah, so it's not uncommon. People make what they call Scrivener's errors. So they just not familiar with the process. People can file what's called an amended personal or declaration, amended declaration of service, and correcting any errors that may have been there. If that's the case, then we can move forward. So they just needs to be filed, and they would need to be noted up for a different date.
Okay.
Yeah. So that's kind of the where we lie with the motion for adequate cause and parenting plan modification. If those things can be remedied, then we can come back at a different date once that has been remedied, and then a new date is chosen and notice is given to the other side, and then we can come back and hear that motion.
So I pretty much need to refile this and get a reservice and redo it.
So what needs to, so it looks like the numerous documents have been served upon Ms. Marquez.
Yeah, it's been a trouble.
Yeah, it's not an easy process. It's definitely not an easy process. And then there was one document that was omitted from that list, which was the summons. And I don't know if that was served or not served. If it wasn't served, it'll need to be served. If it was served, then the declaration needs to be amended or corrected. So that's kind of where we're at on that. So I'm not going to rule on that one today. So that brings us to Ms. Marquez's. Ms. Marquez, do you have any questions about that?
No, I do not.
Okay. So that takes us next to the motion for contempt. And it looked like there was a service on May 2nd to Mr. Sekney, and just confirming that you got the documents related to that.
I did.
Okay. And then related to that motion for contempt, I want to make sure that if Mr. Sekney, if you filed something, I want to make sure that I'm aware of that and have read it. But I don't think that I saw anything that you had filed. And some people, sometimes they do.
I have not had a chance to completely go through this and file a response yet. No, I have not.
Okay. All right.
It's going to take some time.
Okay. And this is related to
There's some pretty serious allegations in this. So
yeah, because the allegations are related to child support and also parenting plan, exercise of parenting plan issues. So so two ways to approach this, and I'll check with Ms. Marquez and Mr. Sekney. Just so you know, generally it's a paper-based process. So documents are printed, people speak their piece in those documents and file with the court. Court reads everything before, and then we come to court, and then everybody explains it kind of in their own words, and sometimes that's easier, and it comes out and it clarifies things. So at this point, I know what Ms. Marquez is saying. I've read what she's indicating, and then I have not read what Mr. Sekney has, what his response is. And so I just want to double check with you, Ms. Marquez, as far as kind of the urgency or non-urgency you feel regarding your motion. Do you want to address that? Because one possibility is we continue the hearing. The other possibility is that we move forward today and hear from Mr. Sekney just verbally. You wouldn't know what he's going to say, and you wouldn't necessarily have an opportunity to be prepared to respond or rebut what he has to say today. So just what are your thoughts as far as the urgency of the matters that you've raised?
It's not that much of an urgency. It's more so of just if he's going to continue to follow our current order, or if he's going to kind of stay AWOL and go by the order that he wants.
Okay. All right. I appreciate the input. So I think what I want to do with the motion for contempt, since they're not what we call urgent, safety issues involving children, is continue the motion for contempt for a period of probably 2 weeks or 3 weeks, and we can talk about date here in just a second. And then that would allow Mr. Sekney to file a written response with the court, give a copy to Ms. Marquez, come back and address that motion.
And is the service on that, can it be emailed? Can we agree on emailing? We've done it in the past before, and the service has been such a trouble with both parties. So if we could agree to just email the service of the records before we come back, I mean, we've done it in the past. I don't see any reason why we shouldn't be able to agree with that.
Okay. Yeah, if parties want to agree to serve each other via email, that tends to make things easier, but there's no obligation on any party to agree or anything. So Ms. Marquez, do you have any comments on that?
We've done that for one document in the past when there were others that were served. I'm not comfortable with it.
All right, so if the parties change their mind related to service by email, then you can certainly do that.
And Your Honor, how am I supposed to go about finding her? Every time she's been served, it's either been in a bar or in an alcohol establishment. I mean, we've had to search for weeks and weeks and had sheriffs do it. And I mean, at what point will I mean, that's
so there it looks like Ms. Marquez has provided an address on Avenue. I'm not sure.
That's not her current address.
That's where she's indicated that she's going to be served. And so, Ms. Marquez, there's a couple different addresses that you've used to file documents. One is Longview. Which address is the address that you indicate to where you can receive documents?
Most commonly my mail goes to Avenue. However,
So you have to choose one. You have to choose one.
It's fine. That's my current residence. The other parties served me at both.
So just so you're aware, so with any pleadings, the parties, it's incumbent upon each of you to make sure your address is updated. And if you change your address, you have to formally notify the court and say, this is the address that I want to have you use. And so if you're making that statement currently on the document, Ms. Marquez, then you're going to be held to that. And then it would have to be on an address where Mr. Sekni could mail items to you and it'd be considered good service. So are you aware of that?
Yeah, we can just keep Avenue.
Okay. So, Madam Clerk, what is the document? Is there a particular document that updates a party's formal address?
Yeah.
Okay.
And Your Honor, she hasn't had a formal updated address for over 3 years. She was her mother's address. She does not reside there. Neither does my child.
Okay. So Ms. Marquez, what you need to do, there's a specific form. It's called a notice of change of address. You'll need to file that. So if you want to take a note of that, it's notice of change of address. You'll need to update that, file that with the court, and then provide a copy to Mr. Sekni so everybody knows where to be able to send you documents so you get them.
Can I ask a question?
Sure.
That's not actually my physical address. I've only moved once in the past 2 years. I just keep that address because that's where all of my mail and like my billing goes and stuff. So it's like the most consistent. I've been served there and yeah, so I don't know if I would need to change it necessarily, even though my physical is different than my mailing.
So I think what would be appropriate, just that it sounds like there's been some confusion. If you could just submit that notice of change of address by the end of this week.
Okay.
So that'll make sure everybody's aware of everybody's address, and that'll allow for service to occur. So taking a look at coming back to hear the issue on the contempt motion, the parties will look at June 5 and tell me what that looks like for your schedules. June 5. It's a Wednesday.
Can I pull up my phone really quick?
You bet.
I'll be off that day, Your Honor.
Okay, great.
At what time? The 9 a.m. docket?
9 a.m. docket, correct.
Yeah, that'll have to work.
Okay, so we'll set the contempt motion over to June 5. We'll hear that, and then we'll get Mr. Sekni's materials, and we'll take a look at things. Then if Mr. Sekni wants to make any correction to any service issues, then that could be noted up on the same date, and it could be heard on the same day. That would be
June 5th docket.
Yeah, that's a potential date. It doesn't have to happen on the date. It might save everybody a little bit of time and trouble.
I think it would be better just because we filed the motion to change the parenting plan, and then we got this in response to that. So it's kind of like we agreed to something, and then now we're not agreeing. So I think it's kind of all in one. It needs to be all brought up in one subject.
Yeah, I mean, if it can happen on the same day, great. It's going to be incumbent upon you to get that petition or the motion for adequate cause to note it up on a particular date after any inadequacies have been rectified. Okay. All right. So we'll see everybody on June 5.
All right. Thank you.
Make sure you're just close to that microphone. It'll pick up your voice and record it clearly.
Thanks.
So you're here, and then I'll ask if Curtis Wilkerson is on the line. Curtis Wilkerson, if you're on the line, please state your name. Looks like there's not a Curtis Wilkerson in the courtroom. So Mr. Wilkerson, just so you're aware, if you are speaking, we can't hear you. I'm looking at the Zoom participant list. I'm not seeing anybody that is remotely close to either Curtis or Vaughn or Wilkerson. This is your motion, Ms. Wilkerson, for default. And it looks like you properly served, so I'm going to grant your motion. I think you gave us a proposed order, did you not?
I believe so, yes, Your Honor. I waited 13 years for this.
Okay, that's a long time.
Yeah, yes, and he wouldn't be on here because he's in Oregon and he doesn't care. So.
Okay. All right, so I've got your proposed order here. And I'm going to sign off on that now.
Do I need to get a copy or anything, Your Honor, of the order?
You can if you'd like.
Yeah, because I have to change my name, so.
Yeah, is it his name Curtis von Wilkerson II?
Yes.
Okay, so it's got the second. So generally what happens is that I sign this order today, I hand it to the clerk. They go through a process in which they get it uploaded to the system. Generally, I tell folks 2 to 3 days. So either this Friday or Monday, you can swing by and get a copy for your purposes.
Thank you so much.
Any questions?
No, sir.
Okay, take care.
Yes, I am.
Thank you.
Okay, welcome.
Good morning. Yes, good morning.
Ivan Molina, are you on the line?
Yes, Your Honor.
Okay, welcome to both of you. All right, we were here a week ago, and I think, let's see, Ms. Height, are you on the line?
Yes, I am, Your Honor.
Okay, welcome to you, Ms. Height. All right, Ms. Brody, there's either some sliding noises or paper rustling that it comes across really loud here at the court, so if you could just help us with that, that'd be.
I apologize.
All right, so a couple of things. We were here last on the 8th of May, so last week, and parties had not yet met with the guardian ad litem, and there was concerns related to withholding of the child and concerns of alcohol abuse and bruises and other concerns. And the indication was that the parties need to speak with Ms. Height no later than yesterday at 7 p.m. And there was some visitation that was to occur in the interim. So I'll just double check with Ms. Height if the parties contacted you.
Your Honor, I did have contact with Mr. Molina after multiple attempts. I was unable to have any contact with Ms. Brody. I do have a brief report of my activities in the last week, when you're ready to hear something like that.
Okay. Yeah, let me, if I can hear from Ms. Brody, tell me what happened as far as the court's direction for you to be in contact and speak with Ms. Height.
Yes, Your Honor. I honestly, I took it as whatever you said, whatever Ms. Heights requested of us was we were to follow through that whole week, and I just we were in correspondence. I was waiting for her to hit my phone number up that she was last in correspondence with. I never got nothing back. The last message was my message to her when she first had reached contact with me. It's the same number. I did not think to hit her up because I was worried about my child coming home. She was not home until yesterday at 2 something from her dad's visit. So I was, and I was told I couldn't even come pick her up. So, I mean, I was a little stressed on.
How many times did you call Ms. Height from the last time we were in court?
Oh, no, I didn't call her, myself. I thought that she was going to be calling and requesting things of me is what I honestly thought.
Okay. When last time we were here, when I said that both parties would need to speak with the guardian ad litem by the cutoff date of May 14th, yesterday at 7 p.m., what did you understand that to mean?
I thought that anything that she had, like, if she was to tell me to meet me here or to like come talk to her, let her see my daughter, I thought that she was going to be telling me instructions on what to do. That's what I honestly thought.
Okay. Then why do you think I said a deadline for you to contact her?
I don't think I heard you correctly. I apologize, Your Honor.
Okay.
My daughter was gone, and it was stressing me out more than anything. I don't think I considered those words to be what they were. I apologize. It was an honest mistake.
Do you have Ms. Height's phone number?
I do.
Okay. So
I can call her right after court if she would be available.
Okay, I'm just going to make sure that we're communicating correctly. You're ordered to contact Ms. Height no later than close of business on Friday and speak with her. Either speak with her when you talk to her or set an appointment and keep that appointment. So tell me what you need to do.
I need to contact Ms. Heights no later than Friday and speak with her and do whatever she's asking me to do.
Okay, all right, thank you.
Mm-hmm.
Ms. Height, maybe I could hear from you and then we'll hear from Mr. Molina.
Okay, but I put together some notes for review for the court, just kind of a quick thumbnail if you would indulge me. I think it will help us get a clear picture today. This case has been complicated, Your Honor, by a high level of strife and mistrust, and by documents being filed in both Cowlitz County and Island County. There have been competing protection orders, some of which have been denied, amended, or struck. There have been dueling proposed parenting plans. There have been accusations of poor parenting and withholding, and there was a previous 2021 parental kidnapping by mother of this child. By my count, there have been 8 judicial officers in Cowlitz County who have heard portions of this case, plus any Island County judicial officers. I found that very unusual. At the termination of my earlier appointment, the plan per Commissioner Nelson was that the parties would put together a parenting plan initiated by Mr. Molina, and until then, the child would stay in Island County with father. An Island County order of December 1st, 2022, ordered that this then 6-year-old child was to live with father Jake Molina in Island County, and mother Summer Brody would have visitation. During the next year, Summer was unable to achieve regular visitation. I believe there were only 2 visits during that time, but there was regular, I think nearly daily video contact between mother and Aaliyah. A year later, in December of 2023, Aaliyah was taken without notice to Mr. Molina as part of a pizza delivery scam. When Mr. Molina could not find his daughter at home, at the neighbor's home, or anywhere in the neighborhood, he called police. And it was through their efforts that they discovered that mother and grandmother had contrived to deliver a pizza to the home and then took the child. There was no known address for Miss Brody. She was unreachable through available phone numbers or mutual acquaintance by either the police or Mr. Molina. And so Aaliyah was completely cut off from contact with her father at that time. 2 months later, little more than 2 months, in February, mother again asked for a restraining order and filed pictures of bruising of, this was several weeks after she picked her up. The date and origin of the bruising was unknown, and pending further investigation, that order was granted. On April 3rd, I was reappointed. I sent out intake packets in an effort to gather a comprehensive updated picture for the court. Also at that hearing, father was granted 2 weekend visits. Neither visit occurred due to Miss Brody's failure to tender the child or to communicate with Mr. Molina. On May 8th, as you have already referenced this morning, Your Honor, the parties were directed by this court to cooperate with the JL investigation. I contacted both parties that day. Mr. Molina was cooperative and responsive and communicative. Before that most recent court order, Ms. Brody had briefly indicated to me that she would be unable to meet or to return paperwork due to undergoing a difficult move. She's not communicated with me at all after the May 8th court appearance, although I made, by my count, 6 various attempts to contact her, leaving messages and also texts, including texts that suggested various times and options for getting together with she and her daughter. During the months that Aaliyah has been with Summer, she has not been enrolled in public school, but there was a report that she has been perhaps in an online service. I've not received any information about the provider. I have not received any information that there was an intent to homeschool filed with the state or of any annual mandatory testing being undertaken. There was an effort by Ms. Brody on Monday of this week to enroll Aaliyah in North Lake School. That same enrollment was attempted after the previous abduction in 2021. The court-ordered visit of May 10th through 12th, ordered by Your Honor last week, occurred. And by Jake's account and by information from 2 other people who witnessed parts of that visit, it went well. I received pictures of fishing, of northern lights, water play, time with family and friends, and reunification with the family dog. After that visit, father returned Aaliyah to the Hall of Justice 2 days late. This is because he was pulled over for a faulty brake light and a problem with his driver's license was discovered. The officer instructed him not to drive until the problem had been remedied by the Department of Licensing. He was able to clear up the matter on Tuesday, and he was able to legally make the 10-hour round trip with Aaliyah. He did give me photos of the documents from the officer. Briefly, Your Honor, I spoke with collateral people, and I haven't indicated who said what, but just kind of a synopsis of those statements of 4 individuals who have known Mr. Molina for over 10 years. They sketched a picture of a patient caring father who's responsible, who's kept his child clean and well fed, who is his main focus, statements that the home was clean and orderly, that he's a hands-on parent, that he does not smoke weed but drinks beer on occasion, that he participates in her school activities. One source stated that Jake and Aaliyah were at his house for dinner the night before Aaliyah was taken, and he remembers her as healthy and well-fed and noted no bruising. He stated she seemed happy and playful with her father at that time. A school counselor noted that about a year ago, Aaliyah had arrived at school crying because her dad had yelled at her for not brushing her teeth. However, she also noted that her behavior at school was within norms. She stated that due to more than 20 absences during the September to December months of the school year, Aaliyah was falling behind academically but was doing okay socially. That number of absences is concerning. Aaliyah's current academic progress is unknown. Aaliyah's housing in Cowlitz County is unknown, including any housemates of mother. Unfounded recent reports of Ms. Brody using street drugs within the last 6 months have been received but are unverified. A hair test is indicated but has not yet been requested due to failure of contact. Criminal records show theft charges by Ms. Brody on each of the last 3 years. The most recent was a first-degree charge in July of 2023. Finally, because of the comparative stability in father's home, because of the many ongoing uncertainties surrounding mother's living arrangements and ability to safely parent this child, because of the court's earlier ruling that the child should reside with father, and because of this erratic kidnapping incident by mother and grandmother, I'm recommending the following today. I'm recommending that Aaliyah be returned to her father's care on Saturday, May 17th by 3 p.m. and that the exchange be made at the Hall of Justice. After a day of getting settled, Aaliyah should be enrolled on Monday, May 20th into Broadview School, and that an appointment be made with Ms. Tang by phone or in person to review any needed remedial learning. There should be no unexcused absences and no tardies between May 20th and the end of the school year. I'm recommending that Jake Molina not consume any alcohol within 8 hours of driving, and that he participate in an SUD screening within 30 days and participate in any recommendations. This is not meant, Your Honor, as an accusation, but a way to confirm or deny allegations leveled multiple times by Ms. Brody. I'm recommending that mother undergo a 17-panel hair test by 4 o'clock today, with the results filed with this GAL in the court, and until receipt of those results, no visitation occur. I'm recommending that mother have phone or video visits on Mondays, Wednesdays, and Saturdays at 5 o'clock or at other agreed times. Upon production of a clean 17-panel hair test, Ms. Brody can file the results and petition the court for in-person visits as follows. Due to twice unilaterally removing Aaliyah from her father's care and subsequently withholding her without contact for extended time, Summer Brody's visits be in Island County, supervised 6 hours every other weekend, either Saturday or Sunday, as agreed by the parties. Supervisor to be agreed, but grandmother not to be a supervisor. During these visits, Aaliyah is not to be taken out of Island County. That concludes my report, Your Honor. I would note that there is a final report, according to my orders appointing, that is due on June 15th. There's no date set for review of that, but it is due to the parties by the 15th.
Okay. All right. Thank you, Ms. Height. All right. So lots of information there. I'll give the parties each a moment to address any concerns or affirmations or confirmations. So first hear from Mr. Molina, then from Ms. Brody.
Yes. When Ms. Heights, I didn't quite hear what you said. You said I need to purchase something in 30 days. What was that? I just want to make sure I have the right thing written down here.
She recommended that you get a SUD evaluation or substance use disorder evaluation within 30 days.
Evaluation. Okay. Yes. Thank you. So I didn't hear it correctly the first time.
Any other comments you'd like to share?
No, Your Honor.
Okay, thank you. Ms. Brody, any comments you'd like to share?
Yes, Your Honor, if I could just read the court something that I had prepared before this hearing, if I
Okay.
may. Okay. Your Honor, if it is okay with the court, I would like to add additional set of eyes on this case. I've asked CPS to get involved with my case for a neutral set of eyes and further investigation. Extra eyes on this case couldn't hurt, Your Honor. Also, Ann Heights can meet with us anytime she is available after school, so we will both be available. Aaliyah is in school and is in active therapy, and also the youth center for kids on Commerce. Plus, we attend church on Sundays. We actually attend 2 churches, Father's House and CKA Celebrate Recovery in Kelso. Where's my other page? My daughter is programming really well and very happy with her schedule. And I had earlier on, like it was a couple months ago, I had a slip up, yes, and I like it's a disease that I'm gonna have to struggle with my entire life. I know that, but I had self-enrolled myself into an intensive outpatient. I'm already in that as we speak. I go to meetings. I'm in Celebrate Recovery, and I am actively tackling that as we speak because I don't want my child to grow up like that, and I don't want to go down that road.
Where are you doing the intensive outpatient?
At Core.
How often are you going?
It's gonna be I start on Tuesday. With they had a long set out or whatever, but my counselor's name will be Mike. He's the main guy at Core, and I'm also doing mental health there as well.
How many hours a week?
However many they make me, as much as I can commute to. I'm trying to keep myself busy. They haven't set my plan fully yet.
So when do you have you've
My
completed?
first, I'm sorry. Go ahead. Oh, my first meet was what was it, Mom? The 7th, Tuesday. Yeah, Tuesday is my first day going in.
Okay, so that's the first time you'll go to Core, correct?
Yes, but it's not the first time it's not my first day in my recovery. I've been doing like I said, my meetings, and I go to my groups all on my own, and like I sought out CPS to be able to open my life to them so that they can see my daughter is in very well hands. I mean, most people close their door to CPS, and I'm trying to ask them to come invade my space so that my daughter gets a fair shot at being heard and seen for what it is, that she's happy and taken care of here, and she does not want to live over there. And she was very neglected. I have dates on my phone, on the hard drive or whatever on my phone of when those pictures were submitted that she had said that it was unclear because obviously they were just photos. I didn't think to put the information of when they were submitted, but when I first got her back, she was traumatized. She was like very timid, very scared. So my main focus was just, coddling my baby at that time. She was very abused, and my daughter and me we were on the phone like Ann said every day and throughout the whole day. Like I would even sometimes put her to bed on the phone because her father would be actively partying, and I was basically a phone babysitter. There was my daughter describing sexual activities in the bed with her where he doesn't let her sleep anywhere outside of his bed. Is concerning. It's not comfortable for her. She's her calling me, telling me that he flipped her completely off the bed, where her temple, it was like maybe a centimeter or 2 away from her temple being bruised, really black bruised for like a month, is very concerning as well. That could have taken my daughter's life. And she just told me when she came back this time that she addressed that with her father again too, and he basically just tells her those things didn't happen. She said she was being bullied over there, and her daddy doesn't help her with anything like that. She said, Daddy doesn't send me to school on Fridays. My daughter would constantly be asking her dad to feed her while I'm on the phone, and I'd have to send her packages all throughout the time, and fast food and stuff deliveries because she wasn't eating. She gained, I think, at least 15 pounds in the first couple of weeks of coming home with me. She's been enrolled since she went back to public school. And her first day was Friday. It was nothing to do with Monday. I don't know how those dates got crossed with Miss Ann, but those facts are not correct. She is actually on a field trip right now with her school too. But her first day of going to school, she all on her own went to the principal's office, addressing how scared she was to be put back in her dad's care and the principal calls me telling me, you know, they want to know more about this. Like, what can we do? I was like, well, I'm in an active case, custody battle with her dad. And she's like, well, it's concerning and it kind of breaks my heart what this little girl feels for her dad. So I decided I wanted CPS. I don't, and I no disrespect to the court or to anybody right now, but I don't feel like I feel like it's a biased situation with the guardian ad litem and this case. So to make it fair, it really honestly can't hurt to have the state have more eyes on the situation. But I really am begging you to let the investigation go a little further before you put my daughter back in that area. If you could just give me a chance.
Okay. Thank you, Ms. Brody. Appreciate your input. Okay, so a couple of things that stand out to the court. One is the educational neglect that's been alleged and set forth. Also, there's concerning for the withholding and taking of a child by a ruse or a scam. There's also concern of ignoring multiple attempts by Ms. Height in the past week to leaving messages and sending texts to Ms. Brody and ignoring Ms. Height's outreach. And there's also concerns for drug relapse. So I think that information is really key that I've heard here today. So first and foremost, I think I'm going to require Ms. Brody to take a hair follicle test by 4 p.m. today and then file the results. So Ms. Brody, can you tell me what I just said?
You said for me to take a hair follicle test and file it by 4 p.m. today?
Yeah, get it done before 4 p.m. today, and then if you can file it today, great. If not, tomorrow morning, and then to send a copy out to Ms. Height and send a copy out to Mr. Molina. So that's the first item to take care of. Second,
Your Honor, Your Honor, this is Ann Height. Can you indicate that needs to be a 17 panel?
Yeah, thank you. Yeah, and Ms. Brody, thank you for that correction. Ms. Brody, make sure that when you're asking for the hair follicle test, let them know you need the 17 panel test, so a test for 17 different drugs.
Okay.
Then I'm ending the restraining order today. That it ends today, right now. And Ms. Brody, your order to return the child on May 17th. That's a Friday at 3 p.m. at the Hall of Justice. It's a good idea to be about 15 minutes early, but your order to be at the Hall of Justice on that date and time with the child and turn the child over to the father. By Mr. Molina, you'll need to enroll your child in school by Monday, May 20th, close of business. And then you'll also need to set an appointment with Ms. Tang at the school to do an educational review for Aaliyah. That also until the end of the school year, she cannot be late. She cannot be have any unexcused absences. Also, Mr. Molina, you're required to consume no alcohol 8 hours before driving with your child. And you'll also need to get an SUD, substance use evaluation. And if they recommend any treatment, then do that treatment. That evaluation needs to be completed within 30 days of today's date. Mother will have visitations on Mondays, Wednesdays, and Saturdays at 5 p.m. And those can be video visits for a reasonable length and duration. And Ms. Brody will need to comply with any substance use disorder and mental health evaluations and treatments. If either of those evaluations have not been completed, then Ms. Brody, you'll need to make sure you complete both evaluations and then follow up and do the recommended treatment.
God, when you're done, can I speak when you're done, please?
Yeah, I'm finished.
I was just wondering, considering the stuff that needs to be addressed and my daughter's well-being and her mental health and stuff, is there any possible way that both of us can just have step aside? Like my mom is a registered foster parent. Can my child be safe? Because her health and her safety is what matters to me most. And I'll jump through whatever hoops regardless. But my daughter, her life already almost was taken once. Okay, and she is crying to anybody that will hear her. She's scared when she's alone with him. She acts a certain way in front of her dad. She says it all the time. Can she please, her safety, please be put first and her not be put back there? Can we just need to have it investigated first, please? Is there a way that she can be taken from both of us right now and be investigated? Because she's crying out and she's only 7 and Please.
So
And I don't drive.
A couple of different things. You indicated that you want an extra pair of eyes, and that's why you're bringing CPS into the situation at this point. That strikes me as concerning, because if CPS was if the child safety was a real concern, then CPS would have been contacted at the time of any potential allegation. We do have an extra pair of eyes. We have the guardian ad litem's eyes here, and there's no showing that those are inadequate. Also, you've indicated that you're willing to jump through any hoops. Well, one of the hoops that the court required you last week was for you to contact Ms. Height. She contacted you 6 times. You did not contact her. So I don't have a much confidence in you jumping through any so-called hoops. So in response to your request, no, that's denied. Those orders that I indicated earlier need to be abided. So Friday, May 17th, 3 p.m. Hall of Justice, child needs to be there. Do not be late. I will draft an order, and that'll be distributed to the parties. Do you have any questions, either Ms. Height, Ms. Brody, or Mr. Molina?
No, Your Honor.
No, Your Honor, thank you.
All right, I will draft that order and distribute it to the parties. So key dates again, Ms. Brody: hair follicle 17 panel today by 4 p.m. no later, and then the child is returned on May 17th, Friday 3 p.m. at the Hall of Justice. And then the other items will be listed of the completion of items that Mr. Molina has to do. That'll terminate the hearing for today. Thank you.
Yes, I'm here, Your Honor.
Okay, welcome, Mr. Miller. And then I'll ask if Angel Amezquita, if you're on the line.
Yeah, I'm here.
Okay. All right. Welcome to both. This is a motion brought by Mr. Miller for a show cause hearing. Let me just double check first. Mr. Miller, I didn't show a proof of service that you'd filed a motion. You'd served Ms. Amezquita with the motion and declaration. However, Ms. Amezquita filed a response, and so I'm not sure where we stand with service.
I have served her. My mother is the one that served her. We had filled out the papers and turned it into the courthouse. I believe it was Friday.
Okay. All right. Let me check with Ms. Amezquita. Ms. Amezquita, did you receive a copy of the documents related to Mr. Miller's motion for contempt?
Yeah, I did.
Okay. So 2 ways to approach this. One, we can proceed today with the assumption that you were properly served with all the documents. Otherwise, we'd need to make sure that the service was effectuated, and I don't have that information today, so we'd have to set the matter over probably 2-3 weeks. So preference on your end, Ms. Amezquita?
I'm fine to go ahead and continue for today.
Okay. All right. We'll indicate that the service was proper. I'll hear from you, Mr. Miller, related to the encounter at Winco and Mr. Chaddock. So I did review that on April 11th was the indication. I did review Ms. Amezquita's response related to the pictures and the receipts. Go ahead, Mr. Miller.
All right. So on April 11th, around 7 p.m., me, my significant other, and her child, along with my son, Buddy, we had gone grocery shopping, went into the store, and proceeding into the entrance, we had noticed that Michael Chaddock was walking out to the exit, and nothing really happened. We walked by, but later proceeded to get towards the back of the store on the opposite end where Mr. Chaddock says he had gone back into the store to purchase milk. And Mr. Chaddock had proceeded to walk up to not me, but my son. When I had my back turned, I was looking at the cheese, but he had proceeded to walk over and try to interact with my son. And from my understanding is the temporary parenting plan we're basing this off of, that he's not supposed to have any sort of involvement with the visitation. And I had asked that he leave me and my family alone 3 times, where he refused, and continuing to try to walk away, he proceeded to almost stalk us around the store. And I had called the police in that matter and asked what I should do due to that interaction, because I have this case in family court where he's not supposed to have involvement with my son. And as noted too, my son, at the time that Michael Chaddock had came up and proceeded to try and talk to him, he was scared and hiding behind my back. I know he still asks me, even now, every time we go to the store, he's scared that he's going to run into him, and, stated that he doesn't want to go to the store because Chaddock will be there. And I know it's caused a lot of traumatic memories for my son because now he brings up a lot of issues, like when he was 5, about all the incidents that occurred over at that house involving Chaddock.
How old is your son now? Is he 6?
He's 7.
He's 7. Okay. Okay, let me ask you a question, Mr. Miller, regarding the order from June of 2023. It restricts Mr. Michael Chaddock from, it says he shall not be part of any visitation with the mother. So here you're asking for a motion for contempt related to not following that order. So it doesn't appear to be a violation of the particular order. It appears to be a very disconcerting interaction for yourself and for your son. So do you have any input on that related to the kind of the basis of any contempt order? Any contempt finding is a court order, and the court order says can't have any participation in any visitation with the mother. There's no, in other words, there's no strict prohibition from contact from him to you or to the child.
Okay. I know I had talked to the police. They had told me to fill out an anti-harassment protection order, so I took the police officer's advice and did that. The order was denied due to just the history of the case and having a previous protection order already. She didn't feel it was necessary. That she said it was an issue that needed resolved in family court.
Okay, so you filed the anti-harassment order. Did you get a temporary order and then there was a full hearing on it and it was denied?
Yes.
Okay, so there's the temporary and then the full. All right. And then the court indicated that did the court give you a written ruling as far as the denial?
As far as I know, it said that there wasn't enough evidence of harassment.
Okay.
Or domestic violence. I kind of based it off of, the history of the case, and the main reason I wanted it was to protect my son, just keep him safe and prevent any future occurrences from happening and prevent this future issue from happening of running into him and having this mishap happen again.
Okay. And I'm just looking. When was that hearing? How recently was that hearing in which the full order was denied?
It was this Monday.
Oh, this past Monday. Okay.
Yes.
Madam Clerk, are you seeing, I pulled up, maybe you can tell me, do you have a cause number by chance, Mr. Miller?
I don't on me. Sorry, Your Honor.
Do you know if it was in the morning or the afternoon when the hearing was held on Monday?
It was 9 a.m.
In the morning. Okay. Okay. Thanks, Mr. Miller. I just reviewed that and it comports. I reviewed the notes and it comports with what you had indicated.
Okay.
Right. Thank you. Anything else you want me to consider, Mr. Miller?
As far as I know from the documents they had turned in as well, concerning the protection order that I tried to get, and what Ms. Amosquita had indicated was that he was in communication that he had tried to come back in the store, and I as far as I know, he knew that my son was there and he chose to try to interact with him, even knowing the history of everything that we've been going through in court.
Okay. All right. Thank you, Mr. Miller. Ms. Amosquita, anything else you want to share?
I just wanted to say that Mr. Chaddock went to the store to buy stuff to unclog our drain, and then he forgot milk. And so he messaged me if I needed anything else, which I showed. And me and him did not know that Mr. Miller and my son would be at Winco. So when he walked back in, he said, when he got home, he told me Mr. Miller was the one harassing him and making a scene and yelling at him. And I told him to just document it. And Mr. Chaddock's concerned about future encounters if Mr. Miller is going to keep harassing him or making a scene, because he doesn't even want to go out in public sometimes because of wanting to run into them and having this happen again. And I understand it's a public place. It's just there's no way to prove either or side.
Okay. All right. Thank you, Ms. Amosquita. Okay. So here, Mr. Miller brings a motion for a show cause on that for a finding of contempt related to the June 8th, 2023 order, which basically says that Mr. Michael Chaddock shall play no part of any visitation time with the mother. That's the order. The order doesn't specify any no contact provisions or anti-harassment provisions. So I'm going to deny the contempt. The order prohibits him from being part of the visitation. This wasn't a visitation at the Winco store. So, you know, word to the wise, I don't think at this point I'm going to order anything other than just telling Mr. Chaddock that he really has no business having any interactions with the Millers, and the Millers really have no any good reason to interact with Mr. Chaddock. The parties be wise to stay away from each other. So I'll deny the motion for contempt and just encourage the parties just to do your best to stay away from each other. That'll conclude the hearing. I'll draft an order to that effect that denies the motion for contempt. Any questions from the parties?
No.
Your Honor, thank you.
All right. Thanks for your time. That'll conclude the hearing for today.
Thank you.
Our last hearing was on April 24th, where the parties were present. And there was it indicated at that time that the court was hesitant to make any changes in the parenting plan until we had seen some treatment records of Mr. Tatum, both mental health and SUD. And I'm just curious, did either party provide those documents to the court? Because when I checked, I didn't see them. Mr. Tatum?
I have not yet. I did order them, and it takes longer than I thought. It takes actually 2 weeks, so I'll check on it today, see if I get them, and go up there.
Okay.
I haven't gone.
So when did you make the request to get them?
About a week and a half ago.
Okay. All right. The clerk indicated that there's this issue with the recording system, so we're going to pause just a second and then restart that recording system. Sorry for the delay, but it won't take long. All right, the system's back up and going. Thanks for your patience. I apologize for the interruption. So about a week and a half ago, Mr. Tatum, you said you ordered those records?
Yes, I did.
Okay. All right, and so I definitely want to see that that information, and then that would give me a little more clear picture. I guess, and I'll hear from Ms. Tatum if she has any comment on this, but I'm looking at continuing the matter a bit until I get those records, able to review them, and then come back and address those issues. But until that time, just leave the parenting schedule based on the domestic violence protection order as is, which means custody remains with Ms. Tatum and no visitation at this point. So I'll hear from Ms. Tatum, then Mr. Tatum.
That's fine with me, Your Honor.
Okay, Mr. Tatum.
Yeah, like Chelsea even said that he would come to court with me and he would write a statement or whatever he needs to do to get this, going further than what it is. That's like in 5 months. I'd like to see my son, and I don't,
How old is Gage?
14.
14. We generally try to avoid involving children in adult matters, and so I'd discourage you from having him write anything to the court.
No, I'm talking about my counselor. He was going to come to court with me, so, but he said he'd write something for me. I woke up late today, so.
You said the counselor might have him write something? Is that what you said?
No, my counselor for SUD. He said either come to court or he'd write a statement or whatever you guys need as far as compliance reports. So I have been going, and like I said, it takes longer to get the compliance reports than I thought. I thought I already had them turned into court. So.
Okay. All right. I appreciate that. All right. So at this point, until we get a little more information, the domestic violence protection order that's in place will still remain in custody. Will be with Ms. Tatum. Next week and the following week, unfortunately, I'm not available. So June 5th would be the next available date. If we were to set it over 1 or 2 weeks, it would be a different judicial officer, so they may not have the same familiarity with the case, but there's nothing that would prohibit that from happening. So I'll just share from the parties, if we could set it over to the 29th, that would leave a little bit of cushion, room for documents to get here. If they were, sometimes it takes longer for stuff to come out. So May 29th, it would be a different judicial officer, or on June 5th. I'll hear from your party, each party, as to your preference.
I would prefer to wait until June 5th.
Okay, Mr. Tatum.
That's fine, Your Honor. I'll wait a little longer, I guess.
All righty. All right. Well, I appreciate both parties being here today. We'll set the matter over to June 5th, 9 a.m. We'll get those records. Mr. Tatum will get those filed with the court and send a copy to Ms. Tatum. Take a look at those and any other declarations you want to supply. If you want to have your counselor submit something, you could have them submit something also. And
all right.
And just make sure you get copies to Ms. Tatum so she sees those, and we'll be back on June 5.
All right, thank you.
Okay, that'll conclude the hearing for today. Thank you.
Yes, I am.
Okay, welcome to you, Ms. Rodriguez. And then I'll ask if, let's see, is Kara Kwashnik on the line? Kara Kwashnik? All right, Ms. Kwashnik, if you are on the line, I can't hear you, so make sure you're unmuted and state your name. I'm just going to check the participant list to see if she may be there. All right, not seeing anything that's remotely similar and no exact match. So, Ms. Rodriguez, this is your motion related to parentage. Looks like service was appropriate on Ms. Kwashnik as of April 8th. And you're asking that parentage be established of Frank Gouland Jr., who was deceased, and you're asking that he be named as the parent or the father, correct?
Yes.
Okay. And you bring this, so I did a little bit of research on this as far as, because you're the grandmother to Serenity, correct?
Yes.
And you have custody of Serenity right now, or you have control and care, and you're caring for Serenity right now and have been for some time. Okay. And I think in your pleadings, you indicated you've had Serenity with you for more than 6 months, maybe pushing 9-10 months.
Since July of last year.
Okay, so pushing a year. Okay. And then did you file, Ms. Rodriguez, did you file, it looks like you filed an order for summary judgment and also a final parentage order. So I have those here. Without hearing any opposition or any feedback from Ms. Kwashnik, who was properly served, I'm in a position to sign both of those orders. So let me just take a moment to finalize those.
Okay.
And is Mr. Frank Gouland, is his legal name, is it a junior?
No, it's just Frank Gouland.
Gouland, okay. Does he have a middle name?
No.
Okay, all right.
I had to ask his dad, and his dad had to look it up.
Okay, and that's where you had you had the DNA testing of his father, and that's where they indicated that it was a 98.5% that he was the grandfather of Serenity.
Yes.
Okay. All right. There's no indication that Ms. Kwashnik is in the courtroom either, by virtue of the fact that nobody stepped up and said, "I'm here." So I've got one other last document to review. Okay, Ms. Rodriguez, I've signed off on both of those orders. If you need copies of those documents, you can check with the clerk's office in roughly 2 to 3 days, and you can get copies.
Okay.
Any questions?
That's just adding her dad to the birth certificate.
I'd have to look at the order again. I think that was in the proposed order, and that was your petitioning for. So that whatever was petitioned for and included in that proposed order, I signed off on.
Okay. Thank you so much.
Okay, thanks. Take care.
You too.
Ms. Roach is here. Mr. Roach is here. All right, great. And thanks for positioning yourselves in front of the microphones. When we were here last week, there was an indication there was some question as far as service. That's what we talked about last week, and we talked about having a hearing here today regarding that issue. So it was related to the proposed temporary parenting plan. I think that's where you, Mr. Roach, indicated that's a document that you had not received. Is that accurate?
Yeah, I got that from here.
Okay, so you have a copy of it?
Yeah, I paid to have it printed.
Okay, all right. Yeah.
After I left court on Wednesday, it was returned to me by the sheriff's department in my mail. So they just couldn't locate him. I have it in my folder here.
Okay. All right, so just want to make sure we're on the same page. So the information that you got back there is returned. It wasn't able to be served. The documents that you got back were the petition, the summons, the parenting plan, the financial declaration, those documents?
For the temporary plan, yes.
Yeah, okay, for the temporary
I think that there was a misunderstanding last week at the court hearing. The service that Barbara was able to serve Bo was service for the petition for a divorce and parenting plan, which wasn't the case, or it wasn't the issue that we were on last week.
Yeah, so it looks like what I guess Barbara Thomas. She indicated that she served Mr. Roach by giving documents to Bo Nelson back on March 1st and gave him a copy of the petition for divorce, a summons, a proposed parenting plan, financial declaration. So I guess that's the one question I have, is that the proposed parenting plan, Mr. Roach said he received all the documents from her, but he didn't get the proposed parenting plan. Is that what you said?
No, I didn't receive any documents that I know of. I got all the documents I got here.
Okay.
Your Honor, I have a
They have
video.
it.
Hold on. So, and then Mr. Nelson, what's his
He's
relation?
my dad.
He's your dad. Okay. And is he here today?
Yes.
Okay. And he was here last week, I think, too.
Yeah, and
Yeah.
if
Okay.
she gave him papers, she didn't say like this is service papers.
Yeah, you don't need to. Yeah, you don't need to. You just need to give the documents to the person, and they kind of the idea is that a person gets documents, they'll read over them and go from there. So you were going to say?
Yes, I have video proof from the day that Bo was served the divorce documents. This was during a transfer because
Do you have that video with you today?
I'm sorry.
Do you have that video with you today?
I do, yeah.
Okay. So one way we could do it, I could hold it up to the camera, and then you would all be able to see it and hear it.
It's more of an audio, but you can see her going up to his car. There's a picture of the service proof. And then when she gets back in, she says that
So just like last week, I told Mr. Nelson not to interrupt. I'll tell you the same thing. Don't interrupt. If I need your assistance, I'll call upon you, but don't interrupt, please. Any questions about that? So, Mr. Roach, do you have any concerns if I were to listen to that audio/video?
No.
Okay, why don't you have it and bring it up, and we'll put it up on the camera and get it on the microphone. And then, Madam Clerk, if we could make my box big. Okay, so I'm unmuting, and then I'm pressing. I'm going to press here and the microphone so we can all hear. So.
it's pretty dark because it was a 7 p.m. transfer, so it was still.
Okay, here we go.
Oh, hold on. Hey, over here.
How long is the video?
A minute and 57 seconds.
Okay.
It's a little muffled.
Hand you back your phone. But Ms. Roach, why don't you tell me about that video, and then we'll hear from Mr. Roach.
Huh?
I'm going to ask her to tell me more about that video, and then you can share what your thoughts are about that video.
So it's pretty muffled, just because the phone was in the car while he was receiving the documents, but you can hear her saying these are for Joe. And he said he already received a copy of these, and she said, no, this is something different. It needs to be looked over more. And he says, okay, I guess I'll serve these to him. And she said, thank you. And they both left. And then that's when she got in and said, done 7/12 to 7/14, which was written 7/13 for the service.
Okay, thanks. Mr. Roach?
I don't know of any of the papers. The only reason I know about any of this is because I came to the courthouse.
Gotcha. Okay. All right. And then Ms. Roach, oh, go ahead.
That was just because I seen her here coming out of the courthouse with paperwork, so I wanted to come see what else might have been filed or whatever.
Okay. All right, good. Ms. Roach, do you have the is Barbara Thomas in the courtroom today?
Yeah.
Why don't you invite Ms. Thomas to come forward and sit next to you, and then I'll hear brief testimony from her, and then I'll hear brief testimony from Mr. Nelson. Thank you. What do you know about any service of documents upon Mr. Roach or Mr. Nelson?
Rachel asked me to serve Joe. I met Joe's dad, Bo, in the parking lot at the Zion Church. I handed him paperwork. I said, these are for Joe. He said, he already has all these? And I said, no, this is something completely different that he needs to get. And he said, okay, I'll give it to him. And I said, okay. And that was that.
And what did you give him?
For the divorce and the parenting plan. I don't know exactly.
Okay, it was represented in the document that you signed.
Huh?
There was a document that you signed. It's a declaration or proof of personal service. Do you remember filling that document out?
Right. I don't remember exactly.
Okay, it said that you gave the following documents to Mr. Nelson: a petition for divorce, a summons, a proposed parenting plan, and a financial declaration.
Yes.
Does that sound right?
Yeah. And I recorded every single document that was on there too.
Okay. All right, thank you. You're free to take a seat back. And then, Mr. Nelson, do you mind coming forward?
LSON.
Thank you. Tell me what you know about any service or non-service.
I had no idea it was being served. Most of my knowledge, you actually had to inform someone they're being served, not just toss them mail, basically. Or here's just some papers. And move on. I was paying attention to 3 kids I was trying to load in a car, make sure they're secured, seat belted, ready to go. And they're all trying to talk to me, hadn't seen me in a week, all super excited, yelling in my ear, happy, all trying to argue to talk to me at the same time. And I did not realize anything was actually serious or real that needed to be taken care of. But it's just some paper. Okay. I didn't press any importance upon it. I didn't really think that it was that important. It wasn't like, you're being served, this is important court paperwork. Oh, okay, thank you. I would have passed some importance upon it and actually made sure it was delivered properly instead of just, it's just some paperwork. Like, don't worry about it. Here.
Okay. And then what did you think the papers were?
I didn't even look at them. I just figured it was personal crap. It's not up to me, or it's not my stuff to read.
And what did you do with the papers?
Last I knew, they were on the seat of the car, and I told them they were in there, but there's some papers in the car. Should probably grab them when he got home from work, but that was it. I didn't realize it was actual stuff that was serious.
What did the papers look like? I mean, is it?
I didn't look at just a couple, like a fold of paper. I just sat it on the seat. I didn't look at it. Wasn't really thinking anything about it. I was trying to pay attention to kids.
Good.
And I do remember I did hear it in there too. I'm not here to do anything besides transport kids.
Gotcha. And then do you and Mr. Roach live together?
He has a large travel trailer up on my property, up on Mount Vernon.
Property. Okay. All right. Great. Thank you. Appreciate it. All right. Any further comment from either party related to the service issue?
No, I just believe that the only service issue is the temporary order.
Okay. All right. Well, having heard from the parties, I heard from Ms. Thomas or Ms. Bartlett. She indicated that she met Mr. Nelson at the Zion Church looks like on March 1st of this year, and said these are for Joe, and he said I'll give them to Joe. And then Mr. Nelson indicated that he was busy with 3 kids, getting him in the car. They were excited to see him. Lots of chatter going on. He had no idea what it was, and under his impression was that if you're being served with official court documents, you had to say something like, "Hey, I'm serving you official court documents," or "You're served," or some kind of language to tip him off. And he just didn't think they were important. Just thought of some personal stuff, tossed him on the seat, and said, "Hey, Joe, there's some papers on the seat." I guess is kind of the idea, and that they live on Mr. Roach and Mr. Nelson live on the same property. So with that information, it looks like the service was properly effectuated on March 1st. And there's, I think a lot of times in the media, we see, those famous words, "You're served," kind of dramatic fashion. There's no necessary requirement for that. It's basically that the documents are given to an individual who's a person of suitable age and discretion that lives at the same property with the other party. So they call that substitute service, and that's allowed by the court rules. So I'll find that there was proper service. So now that takes us to the point where we've established that there's been proper service. And it sounds like Mr. Roach has got copies of the documents. So now I know what Ms. Roach wants as far as a parenting plan. I don't know what you want. And so that's where you would submit your declarations and information related to your proposed parenting plan and your declarations of why you feel that parenting plan is in the best interest of the child or the children, pardon me. So that's kind of where we're at right now. So service is good. That first hurdle has been cleared. Then the next step is to hear from both parties as to what, I know what Ms. Roach wants as far as the parenting plan. I need to hear what Mr. Roach wants for his parenting plan. So as far as getting that information submitted, what are your timeframes? What are you thinking how long will it take you to get that proposed parenting plan in, and any declarations supporting your position?
As soon as possible.
Okay. So why don't we do this? Why don't we just set a time frame? This has been pending for quite some time. So with today being the 15th, let's set the case for May 29th. May 29th is a Wednesday. It's 2 weeks from today. That means, Mr. Roach, you'll need to get your proposed parenting plan and also any declarations from yourself and other people that kind of explain the situation. You'll need to have those filed by the 20th and send a copy to Ms. Roach. And then Ms. Roach will have an opportunity to respond or reply to your documents with any declarations that she has. So any questions on how we're going to proceed?
Yeah. Confused.
Yeah. So a couple different things. There's
How am I supposed to, like, give her a copy?
So yeah, it's a great question. Ms. Roach has an address on 20. You can mail them to her. You can mail them to her at that address, and then you have to submit a document like proof of personal service or a declaration of service or an affidavit of service that. So there's a couple of things I want you to remember. WashingtonLawHelp.org. WashingtonLawHelp.org. Go there, look under divorce. And then you'll find lots of information about service, declarations of service, and you'll also find, and they'll have blank forms. And they'll also have blank forms for proposed parenting plans. And so you just fill those out, and then you'll send a copy of them to Ms. Roach at her address on 27th Avenue, and then you'll file the originals with the court. And so we have those, and you have to do that by the 20th, by Monday the 20th, by 5 p.m. I think the clerk's office closes at 4:30, so be there before 4:30. So those are the next steps. If you have any declarations or comments about your proposed parenting plan, look under that same website, WashingtonLawHelp.org, and they'll have those same forms, and you can type those out or write them out by hand and submit them to the court. That make sense?
Yeah.
Okay.
So I still can't see my kids.
At this point, I'm not making any ruling because I don't know what the status of your viewpoint is and her viewpoint is either. So that's why it's important for you to have your voice heard, and your voice is going to be heard via your declaration, which you're going to submit, and your voice will be heard on the 29th of May at 9:00 in the morning.
Okay.
Ms. Roach, do you have any questions?
So we're not putting anything in place today?
Correct.
Okay,
Correct. All right. So we'll see everybody on the 29th of May.
thank you.
All right. Thanks.
Good. Go to the quick thing, you get the parenting plan, or never mind, you said go online.
Yeah, you can go to the clerk's office and you can buy, I think you can get a packet there. That's one option. So you can check with them or the Washington Law Help. Yeah. Yep. Yep. Perfect. Yeah. And in future hearings, we have some hearing devices that can amplify things. So that would be. Okay. And you're welcome to sit up closer too. And if you wanted to sit up here in the future, that would be fine too. Alexis Meerendorf? Okay. And you're Mr. Robert Warmdahl?
Yes, correct.
So let's see, a couple of different things. We're here on Mr. Warmdahl's motion for a temporary parenting plan. And also there's an existing restraining order that's in place, and a request to extend that potentially, if I'm not mistaken. Is that kind of where we're at?
That sounds about right, yeah.
Okay. And so I read from each of you information that you submitted regarding proposed parenting plans, also about there was a little bit of information about incomes from at least Ms. Meerendorf.
And if I may say something.
Sure.
I was required to put that in because I get state insurance and stuff like that. So I have to.
Right. Right. Yeah, not faulting you. I was just noting it that happens.
Oh.
Let me talk to the parties just a little bit. I'm scheduled today to be at the Expo Center at noon to give a presentation. You're more important, at least in my mind, than that group. I have two other people who can carry on that conversation. Would it be better if I was there? I think it would be better, but I just wanted to touch base with the parties on. I don't want to short circuit this. Like if you feel like these issues are urgent and important, then we will hear it today and we'll get it done today. However, if you feel like it could be set over 1 week, then we could address it next week. But I just want to hear from each of you first before I make that decision. Mr. Warmdahl, this is your motion. So what are your thoughts?
If everything stays the same as it is right now, I don't mind waiting 1 more week at all, but
Okay.
I wouldn't mind proceeding and.
Sure. You've been waiting all morning. Yeah. Okay. Thanks. Ms. Meerendorf?
I don't mind, but then I do. It's been months since I've seen my son, and I really just want to settle it and know what I need to do next. Like if I have to take it to trial and get a lawyer, or if we can settle on a parenting plan together. Okay.
All right. Well, let's move forward today. And we can address it. And if I can get over there, I'll get over there. If not, I don't. So I wanted to ask initially, Mr. Warmdahl, you indicated that there was hospitalization of the child, and this is the child that's 3 years old.
He's currently 4, but he had to get thorough examination after the incident involving his brother.
And that was back in February of 2023.
Yes.
Okay. So are there new concerns that have arisen since that date?
Not really. He's been pretty decent. Like,
When I say concerns, I want to make sure that, because I wrote down in my notes that the 3-year-old, that there was abuse of him and it resulted in hospitalization. Is that true or not true?
it is true. When you raise your voice to him, he kind of cowers. He'll put a hand up or something. And even now, we went outside, and the first thing he said when we left the house was, "Don't hit me." And that's very alarming. I do give him 3 spankings across the bottom, but I never hit him.
Okay. So is there a specific date and time where you're alleging that there was physical abuse and that resulted in hospitalization?
It would have been inside their apartment because at the time, I was working in California, 2-layer California, putting a roof on a building. So I wasn't even around really. And then
What time frame was that?
So I left for 2-layer at the end of July, and then I was there for 3 to 4 months.
Okay, so July to maybe October, you're in California?
Yeah.
Or November? Okay. And so that's where you're saying that potential abuse occurred?
Yeah.
And then do you know, was the child hospitalized during that time frame?
He just got a checkup for possible abuse.
Okay. And did you look at any medical records from that checkup?
No, there was no actual linkage to abuse for Elias.
Okay. All right. So it sounds like your main concern is kind of how he cowers and he says, "Don't hit me." Is that your main concern at this point?
It's part of it. It's just Randall is tied to Alexis through his child eyes. Like when she sees him, he reverts to different behaviors and acts differently than, like, there's a lot of trauma attached with the death of his brother.
Okay. And so you said when Elias is the 4-year-old, right?
Yes.
You said when Elias sees who that it brings back memories.
Alexis.
Oh, when he sees mom.
Yeah.
Okay. Okay. Because he you're saying that he correlates seeing mom with his brother and
Randall.
And Randall, has Randall been convicted?
Yes.
Okay, he's serving time.
He got 7 years.
Okay.
No, he didn't.
No.
He got 5 years for that.
Okay. All right. Okay. And then when was the last time that Elias saw mom?
It's been months.
Christmas. After dinner.
Was Christmas?
Yes.
Does that sound right?
Yeah.
Okay. And then can you tell me why there hasn't been other visits since then?
So we were doing supervised visitations, and then there are certain points where the supervising part didn't work out. And later on, I realized that not all those supervised visits were actually getting supervised or anything. And when I confronted about it, the asking for visits just kind of stopped. Like I stopped receiving messages and asking for them.
Okay. All right. Okay. And then I'm just going to jump back and forth a little bit between the two. Ms. Mehrendorf, did you stop asking for visits at a certain point?
Did not. I tried calling and texting, but my number was blocked. I don't know if it was Mr. Wendell himself doing it, or if it was his girlfriend. There was a lot of conflict for pickups and drop-offs. My mother was there through every to supervise everyone. She just wasn't there to drop him off with me, as she cannot drive at night or see at night.
Okay. And so you made efforts to make, contact Mr. Warmdahl, but you were unsuccessful. And
Yes.
what other steps did you take to try to get visits or see the child?
I've had my mother and siblings message him. I don't know if they actually did. I don't know how true that is, just because I'm blocked on my end. I wanted to try to reach him a different way.
Okay. And then it looks like Mr. Warmdahl was one that filed this petition for a parenting plan. I'm just kind of curious if a parent hasn't seen their child in a number of months, and you're reaching out and numbers are blocked and you're not sure if there's communication. Tell me what else you did to try to make contact.
I did do a parenting plan, but by the time I came in to submit mine, he had already came in a couple hours before me.
Okay.
To submit his, and
Okay.
I couldn't. I know he was wanting to rush into it, but my son was murdered and taken from me when I was at work. I needed time to heal. I did not want to go right back to seeing Elias. I've tried to express this to him, like I need time. I'm grieving. I'm not doing good, and it just came into a that's not my problem type of thing.
So
I just needed time.
So at the time, so in February of 2023, when you lost your other child, was Elias living with you or living with Mr. Warmdahl?
Mr. Wormdahl was not around very much. He is a good father. I will say that he's a good father. He did try to be around as much as he could, but he just wasn't seeing him as much as he would have wanted to.
So did you have the child,
Yes,
Elias,
he was
primarily
in
with you? Okay.
Elias, yeah.
And so then after you lost your son, then is Mr. Warmdahl had greater custody as you kind of grieved and were working through that?
Yes, my son was taken from me and given to Mr. Wormdahl.
When you say taken?
Huh?
When you say taken from you and given to Mr.
The state took him out of my custody.
Okay. And what you understand, is that just because you were in that state of shock and grieving, not able to care?
I believe so. So when I first arrived at the hospital, I did not hear anything about what was happening with my son. I didn't know what was happening. I did not know at the time that he was dying. I immediately got up there, and Detective DeLapp, one from the Longview Police Department, wanted to speak with me. I forgot the other guy's name. I just it looks like James Bond. And they told me that my son is dying and that Randall hurt him. I was in complete denial. I did not believe that he did it at the time, but I had just gotten there.
Okay.
I think anyone would be in denial about that until realization started to hit, and then yeah,
So I guess my question is focusing on Elias. So thereafter, when did Elias go to Mr. Warmdahl's house?
I want to say the 14th of February is when he was gonna be in his custody.
So shortly after.
Yeah, like Anakin was hospitalized the 13th.
Okay.
And I went there that
Yeah.
day.
Okay. All right. And so since Mr. Warmdahl's had the child, what was your visitation like up until looks like until Christmas?
Well, we had court-ordered visitation 1 day a week on Sundays.
Okay.
From 12 p.m. till 4 p.m., sometimes extended for longer.
Okay. So that was based on a court order. And was that in a dependency type hearing, or was that in a family law matter or no contact order?
I am no contact order, I think. I'm not very sure about it.
Okay. Do you remember Mr. Warmdahl?
There was no contact order in the protection plan. So
Is it like the CPS protection plan?
yeah, after the event happened, immediately after, my birth mom showed up and got Elias and took him back to the Tri-Cities where he was born. And she took care of him for like a month and a half or so while I was working. And I came back and me and my son went to my parents.
Okay. And then you were in California for a period of time. Your parents were caring for Elias?
My birth mom was,
Birth
because
mother.
I'm adopted, weird family thing.
Okay. All right. And is that order still in place?
I believe so. It should be.
Okay. Let's take a look here.
Is it okay if I talk, Your Honor?
It is. I'm just pulling up what I think is an anti-harassment order.
Because that protection order should have ended. That's when I submitted my parenting plan. I got really panicked because I thought that she was going to have access back to our son. So I put in a parenting plan as soon as that thing ended.
So that was in April. So April 17th, 2023, there's an anti-harassment order that allowed for the 1 day a week visitation. That was in April of last year. Okay. So I'm a little bit behind the 8 ball because last time we were here, I asked the parties to submit some additional information. You submitted some additional information, Ms. Middendorf, Mr. Warnbell. I didn't get anything else from you. Did you submit anything else?
I did submit a declaration.
Okay.
And Alexis got a copy, but I didn't submit it until 8:30 this morning when the window opened.
Okay. All right. So that would be important information for me to have, just to consider that a little bit more. It's so we have Ms. Mierendorf's proposed parenting plan is that she wants to be basically a 50-50 plan, correct? And then Mr. Warnbell, yours is that you're the primary custodial parent and that at this point, Ms. Mierendorf would not have any residential time with the child, correct?
At this point.
At this point, okay. And what are you looking for in order that she would have residential time?
Cool. So Elias is 4 going on 5 and about to be getting into kindergarten. I really like a buffer between my family and hers, and I think this public school would be the best buffer. So she could like have her visits after school or pick him up after school or whatever. And then we could do our transfers and anything else without me and her actually associating that much.
And I think Ms. Mierendorf, she recommended like an exchange be in a public place and
Yes.
by no third parties.
Yeah, there's too much conflict with his girlfriend being there. Every single time there's pickups or drop-offs, it was always, you're a baby killer, you're not his mother. And I just don't want to. She knows it's the only way that can make me cry and get to me. I just don't want to.
Sure.
But otherwise, I was also agreeing with the school schedule, like pickups, Monday after school, I would pick him up. Next Monday after school, he would pick him up. That way there's no contact unless it's like winter, summer break.
What do we do until then? Because he's not in school yet, right?
No, not yet.
Okay.
I would like to recommend either picking up or dropping off at the courthouse. My mother can always meet him and then she can bring him to me and and stuff like that.
Okay. So the information you dropped off today, was it was it your declaration? Kind of like your viewpoint of what do you think things should be, or what was it that you dropped off this morning?
It was pretty much saying that she wasn't very fit for parenthood.
Okay. All right. So I think I need to read all the information that's out there. Ms. Mierendorf, it's been a long time since she's had contact with her child. And so I'm just going to set it over 1 week so I can review those documents that have been you've submitted. And then did you give a copy to Ms.?
Yes, I did.
Okay, and you got those copies?
Yes.
Okay. You're free to respond if you want to submit anything in response to what he submitted to you today. So if you want to file something, you can. Just make sure he gets a copy of what you file. Go ahead.
Do I have to give him a copy of like everything? Because I submitted like a police report and stuff.
Yeah, I got that. I read that.
All right, do I have to submit a copy to him too?
Yeah.
that.
Yeah, anytime you file anything with the court, you have to give a copy to the other side.
Okay.
Okay. So let's do that. And I apologize, we can't address it. I think it's important that I hear from both sides. And I also think it's okay to continue it 1 week, just simply because there's going to be a continuation of a pattern that's been there since December. So there's not going to be any great trauma that I think would be inflicted if we continue it 1 week. So I'm going to continue it that 1 week. We'll have an opportunity to hear more from each of you, and then I can make a better decision related to the parenting plan. So would both of you be available next week, which is on May 22nd at 9 a.m.?
All right.
May 22nd. What day is that?
Wednesday. It's a week from today. It's a week from today at 9. What's your schedule like?
I'm a full-time student. It's off school throughout the day, but I don't need to go to that class. It's not a very important one.
Okay. Yeah, if you can make be flexible with that would be great. So we'll see everybody next week, and we'll make some decisions on the parenting plan. Okay.
Thank you.
Thanks for your patience. Right. So that ends the docket. I don't have any other matters that are on the docket that have not been addressed. If you have some, please let me know, and we can address any issues that have not been addressed. All right, very good. That'll end the docket. I'll go ahead and disconnect the Zoom.